So, my name's Inspector Claire Searson. I'm a Chartered Town Planner and a member of the Institute of Historic Building Conservation. I'm the inspector appointed by the Secretary of State to hold this inquiry. I'm going to deal with some housekeeping matters first. Ms. Dring, I think your microphone's on. If you want to turn it, there we go. Red means on, and no light means off. Just so you're not heard when you shouldn't be. Okay. So today's the hottest day of the year. You may have noticed. I'm absolutely thrilled everyone's made it in. I did expect a few emails this morning saying trains were cancelled, etc. Please just be comfortable. It's quite a comfortable room with air conditioning, which is very much a relief. But if we need extra breaks, just let me know. Drinks on the table, etc. So please just be comfortable. I have a confession to make. So I sent by parcel force a number of boxes down to the council offices on Friday, including my shoes in them. They've not made it, so I have no boxes of proofs with me. I have no posh shoes. I don't normally do inquiries in flip-flops. I had all hoped you were going to all wear Hawaiian shirts and shorts, but anyway, hopefully they'll come. It shouldn't affect anything much because the first 2 days are fairly relaxed. I've got the proofs I need in terms of the roundtable sessions this afternoon, so hopefully they'll arrive and all will be well and I can wear my posh shoes. Mobile phones, if they can be switched off or to silent, please. And if you can please fill out the attendance sheets. They're on the table at the side there. And Ms. Vincent will collect them at the end of the day. Fire alarms. There's a fire alarm test every Friday at 11 o'clock. Any other time it's real. If we leave by the nearest fire exit, which should be marked, or through the front doors to Tooley Street, and make our way to the agreed assembly point, which is at St John's Churchyard, and we should be accompanied by the council for that. Hopefully all fine, but go. Okay. With the weather, there is a concern that I think there's issues with IT and the fact it may melt. That's not a technical term. The live stream may drop out. I think that's the main concern, but it is still being recorded. We'll just have to see how we get on. I'm hoping we will be okay. And if anyone is watching on live stream, if it does drop out, the recordings should be available at the end of the day, so no one should miss out on anything. Teams wouldn't continue to work. We don't actually have anyone booked today to speak via Teams. But if there is an issue, or if anyone's concerned that they're missing something and there's procedural issues or unfairness, if you raise that to the attention of Joanna Vincent, the programme officer, and she'll let me know, and we'll just have to sort of see how we get on, but fingers crossed. Obviously, in quite a big room, I think if people can come in and out via the rear doors, I'll use this door, but the middle door's quite distracting for those around the table as well. I think that's it in terms of housekeeping. So. Okay, so the inquiry relates to the non-determination of 4 applications, 2 planning and 2 listed building consents. These appeals have been recovered by the Secretary of State. I will therefore be writing a report of recommendation rather than issuing a decision myself for those that are not familiar with that. So the description of the development. So we have a 2018 scheme, and that's redevelopment to include the demolition of the 1980s office buildings and erection of a 37-storey building plus 2 basement levels of a maximum height of 144 metres, restoration and refurbishment of the listed terrace, numbers 4 to 16 St Thomas Street, and other change of use, B1 floor space. I'll not read out the full descriptions because we'll be here all morning. But There's an accompanying listed building proposal, and that's the restoration, rebuilding and refurbishment of the listed terrace number 14 to 16 St Thomas Street, and that includes the demolition of 1980s fabric across the rear elevation, demolition of the detached 1980s office building, and reinstatement of the rear elevation and provision of shop fronts. There's then also a 2021 scheme which is similar, but it's for a 26-storey building with different floor space. The associated listed building consent largely similar, but no rear shop fronts. And if we'll reference them from now on as the 2018 scheme and the 2021 scheme. Okay. I've just got to run over a few things this morning to explain for benefit of interested people and general public the procedure we'll be using for this inquiry, detailing with procedural matters of clarification, documentation, confirming the main issues, deal with any submissions and outline the programme for the inquiry. Firstly though, can I take the name of those wishing to speak and their position? So if I turn to the appellants team first, please.
So I'm doing all my exercise in the inquiry room.
Thank you.
Very good. That's it. It's the hardest I intend to work today. So, Chris Katkowski.
Can you turn your microphone on, please?
I'm Chris Katkowski and I've got my microphone on. So, I'm a QC. If you cough in the middle of my surname, you'll be fine. So it's Katkowski. I'm instructed together with my learned friend, Mr. Alan Evans of Council, who's sitting 2 down to my left. And together we're instructed by Town Legal, and in due course I intend to call the following 3 witnesses to give evidence. That's Mr. Alford, scheme architect, Mr. Stewart, who deals with townscape and heritage matters, and Mr. Goddard, who deals with planning. And then separately, as you know, at the round table session you're going to have later on today on servicing, the witness who will be participating in that from our perspective is Mr. Vaughan.
Thank you.
Thank you.
And for the council, please.
Morning, madam. Just have the list handed around. So, madam, my name is Hereward Philpott, QC, and I appear together with Miss Caroline Daly at Council. And we're instructed by London Borough of Southwark, and we intend to call 3 witnesses. Dr. Nigel Barker-Mills, who deals with heritage matters, Miss Elizabeth Adams, who deals with the architectural townscape matters, and then Mr. Michael Glasgow, who deals with the planning matters, and Mr. Glasgow will also appear at the round table session in terms of the council's perspective on the servicing points.
Thank you very much. And for Historic England as the Rule 6 party.
Good morning, madam. My name's Emma Dring of Council. Sorry, I haven't done a piece of paper. I wasn't sure we were still doing those back to these days of being in person. But anyway, it's a short list. I'm instructed by Beth Harris, solicitor at Historic England. And in due course, I will call Alistair Young, who sits next to me, on heritage, obviously. Thank you.
Okay. So in terms of just going around each of the parties, in terms of the appellant, I've had proofs from all and rebuttals from all. For the council, I've had proofs from all, no rebuttals, but I have had a statement from Mr. Stephen Platts, Director of Planning and Growth, which has sought to address points raised by Salman Alford, and there was email correspondence about that last week, which it should it has been accepted. I think it's on the website, or if not, it will be shortly. I hadn't got any questions of Mr. Platts on that document at this stage, but if anything arises during the course of examination, I'll let you know as soon as possible, because I know you were able to make him available if necessary.
Absolutely. We hadn't intended to put him forward, but if you or others have questions for him, of course, we'll make him available.
Yeah, well, at this stage, I don't, but just I will keep you posted. And then I've had the proof from Mr. Young and no rebuttal. Yeah, okay, thank you.
Just in relation to Mr. Platts, I hadn't realised that you'd accepted the document in, which is absolutely fine. There's not a problem with that at all. But you might recall from the email correspondence, we indicated that if you did accept Mr. Platt's witness statement, if you like, that we would want to consider putting in a brief written response in relation to what he says about various meetings and so on. Okay. We have that ready, and we can submit it. I think documents are submitted to your programme officer.
Yes, I'll come to document later. Indeed. But
so just to mention that.
Yeah, okay. So I didn't realise that message hadn't gone back, but I accepted it. I rather assumed you were just on with a written statement anyway. So
that's fine. No problem at all. That's absolutely fine. Okay. And to be honest, as far as I'm concerned, it's all very interesting, but nothing much to the point. But we did feel that one of the points needs to be responded to. So when my learned friend sees the statement, I imagine that.
Okay, well, I'll come on to documents later on then. Okay, thank you. Okay, interested parties. I don't know if we've actually got any interested parties with us today who were wishing to speak. Silence. No one. Okay, I know we did have some requests. So Guy's and St Thomas Trust have requested to speak. They can only attend on the 29th at 9:30, so we will adjust the programme to accommodate them, and I have asked for a written transcript to be sent as well, so we know what's going to be said. There was a request from somebody called Hygen wishing to speak via Teams. We've not heard anything back from them.
I've now received written statements.
Okay.
He may still potentially want just a little time slot.
Okay, I think. Okay, if you can liaise with them, please, and then if they wish to speak, we'll get them slotted in. If not, we'll get the written statement as an inquiry document, and then we can deal with that as necessary. Okay, thank you. Okay.
Hygen, sorry.
Yeah, it was only one. It was Haijun.
Haijun. Hygen.
So I wasn't sure if that was a Christian name or a surname, but
no.
Yeah.
Okay, thank you very much.
Okay. I've had the notification letters sent from the council, which confirms the date, time and location of the inquiry and the list of those to whom the notification was sent. I also, I'll talk about the site visit later, but I did see some site notices around about the site, which is always a relief for me. We've received representations made in response to the appeal notification. These are in addition to those made in response to the planning applications and the list of building consent applications. These include representations from the Victorian Society, Cathedrals Fabric Commission for England, Heathrow Airport, London Fire Brigade, Transport for London, who we're seeing later. National Trust have sent in a request end of last week, I think, or early this week, to send in a written submission. We've had also one from SAVE. I'm hoping, in terms of the SAVE one, that's been circulated around so everyone can see it. If not, we'll aim to do that. We've seen
SAVE, but we haven't seen the others you've mentioned.
Okay. Oh, so the Victorian Society and they were sent. They were sent in quite a while ago with the appeals. So let me know if you haven't seen them, and we'll.
Presumably they're all. I know you're coming to documents, but presumably there'll be a file on the website.
I don't know if they are actually. We check
Because
that.
that would be these.
Yeah.
Sorry.
Okay. No. I accessed them on our internal system just the other day, but we'll check that. Okay. No. Right. We'll try and get them on. We'll advise on it. Okay. Okay. Proofs of evidence. Obviously, I've been through those that I've received, and no one's highlighted to me that any that I've missed, which is a relief. I've read all the proofs, so I would take them to be largely as read. There's no reason to read them out in detail, but obviously draw on them as part of the examination. For those of you not aware, we had a case management conference. It was held in April to discuss the handling of the case. It's quite a standard thing for inquiries now to do. And a post-case management conference summary note was issued by myself, and that is on the inquiry website. It was literally just to talk about the handling and the main issues and how it's all going to be organised. Okay. Statements of common ground. So I've only had a signed version of the heritage statement of common ground. Brownie points for that one, because that is an excellent one, and I felt you listened to me in terms of that at the me banging on about them at the case management conference. Bit concerned I've only got very few other statements of common ground. So I have a draft version of the overarching one, and that was marked as version 6, and that was sent via Leanne Palmer at Planning Inspector on the 23rd of
Is that the planning
June.
one, ma'am?
Pardon?
Is that the planning statement of common ground you just mentioned?
I think it's the sort of general one that
Yeah. So, ma'am, that's the final version I'm instructed, submitted to PINS on Friday.
That one is, but there was one submitted Friday, which is signed.
The one I've got, which I think is the final signed one, is the 7th version, which is 15th of July.
Very little change.
right.
I've gone to
Yeah.
Okay, I haven't seen that.
I have got one which is signed. It's a 7th draft. It's 15th of July. So if you haven't got that, that's the one you need to have.
Right. Okay. If that can be resent to programme officer, please. And so is that an overarching one, or is that a planning one? Just so I'm clear. Does it encompass planning? Yeah.
We call it planning, but it's overarching, ma'am.
Yeah.
I think there's a brownie point on its way, so it hasn't quite arrived yet.
Okay. All right. Well, if that one can be emailed again. And then I've had a draft version of the servicing one, and that was sent on Friday.
I understand that the servicing statement on ground has now been agreed.
Exactly.
I haven't got a signed version, but I understand that agreed text is in existence.
It is in its agreed form, as I understand.
It's signed by the appellant. We have a version that is signed. It's the same version, but TfL have an internal.
Well, everyone's in the room today, so.
Okay. I think perhaps if that can be looked at over the lunch break.
Sure.
I don't know what time TfL are intending to arrive, but are they here already?
Yeah.
Okay, if that can be looked at. So I've got the most up-to-date version, because I think the version I got, there was still a little bit of movement, maybe. That's as far as I recollect. Okay. And then I'm waiting on character and appearance statements of common ground.
My understanding of the latest position on that, I think the ball is in our court at the moment on that one. I have seen a revised version, which I understand is shortly going to go to the appellant's team. I think there were still some points being checked internally, so I can't see exactly when it's going to come across, but it is imminent. It's cut back quite a bit, but I hope it'll still be capable of being agreed and hopefully also still helpful. But of the 4, it's probably the most difficult to find easy ways of getting common ground, but there is useful information in it.
Okay. Is that your understanding as well?
It's now, ma'am.
Yeah. Okay. Can I set can I have it'd be helpful for me to have it before we start with examination. So can I say Wednesday lunchtime deadline for that at the latest?
Yes, I don't envisage any difficulty as long as the response is not to add lots of things in, then I don't think there'll be a problem with that.
Okay. I think if you can keep me updated as to progress if there are any issues, but I'm hoping not.
I think there's a chance we get it today then, because
yes, exactly.
It's Wednesday tomorrow.
That's what I'm anticipating. Yes.
Okay. Okay. As set out at the case management conference, the main issues for these cases are the effect on designated heritage assets. I've not listed them because it would make it huge, and the effect on the character and appearance of the area. We will be considering the effect upon servicing and highway safety, and that will be done by a roundtable session later. Not proposing to have that as a main issue, but may need to elevate that depending on the nature of the discussions later. We'll also have a discussion on planning matters, including the planning policy context, public benefits and the planning balance. The legal duties set out under section 38(6) of the Planning Compulsory Purchase Act 2004, section 72 of the Town and Country Planning Act 1990, and section 66 of the Planning List of Buildings and Conservation Areas Act 1990, which underpins these matters. And I've missed section 16 of the latter act as well. Okay. Conditions and planning obligations. These will be discussed towards the end of proceedings. For those that aren't familiar, it does not mean made up my mind the way I will be recommending the cases. It's just an opportunity to discuss such matters while we're able. I also have to put them in the report to the Secretary of State, regardless of any recommendation in any case. And this discussion is without prejudice to anybody's cases. I've had two sets of conditions come in, one for planning and list of building conditions for the 2018 scheme and the same for the 2021 scheme, and these are set out in tabular form, which shows the ongoing negotiations between parties and whether agreement has been reached. They're quite lengthy documents. I didn't have time at the end of last week to have a full review of them. I think there's about over 60 on each to go through. What I tend to do is I'll review them. I'll issue a document with my shorthand track changes comments on them, just querying things up front. So by the time we get to the conditions section, hopefully things will be resolved or we'll have answers, and it just foreshortens that session. What I would like though is a clean copy in Word. So I know they're set out in tabular form at the minute, and it shows me the sort of the journey, I suppose. But if I can have a clean copy of the agreed conditions, if there are any unagreed conditions, just highlight them in red and put the two different versions in, and then I'll do a track changes comments in those documents, please. We've got, I mean, it's in 4 weeks' time. I think 3 or 4 weeks' time we'll be looking at those. So we've got time to do that. If I can have them by next week, mid next week or something, that would be helpful. Okay. Right. Oh, and I will also need written confirmation from the appellants about any pre-commencement conditions as well. And then in terms of planning obligations, it was Friday, I got 3 versions. So I got a draft section 106 2018 version, the clean 2021 version, and a track changes 2021 version. And then there was a covering letter accompanying that, just setting out the scope of what the obligations contain. It's financial contributions, section 278 highways works, travel plans, station works, affordable workspace, and plans and drawings as well. I understand negotiations are ongoing, so it'd be helpful just to know where we are at this stage with that. Don't know who wants to.
Louise Samuel, Town Legal. So I think it's important to note that the track is to show the difference between 2018's version, which we've all parties have concentrated on that one basically first. So the track isn't negotiation, that's just the position between 2018 and 2021.
Okay, thank you, that's helpful.
So that's the first version of the 21 that we've seen, so that hasn't as yet been commented on by the appellant team, but we don't anticipate that there's much change. It's just that we got to that Friday with 2018, created a 2021, so you've got both, and then we'll work on both together. In some, I think, with the council's team, I'm looking around at Sophie, we're pretty much agreed. TfL provided comments within, I don't know, a week or so ago, so that's the position that's still now evolving, really. So there's a few things between the council, but not very much. And then we're just having three-way conversations at the moment with TfL, and then we'll reflect that across onto the 2021.
Okay, thank you. Does that... Oh, sorry, did you want to speak, sir? Okay. Yeah, okay. Thank you. And is that the council's understanding of things?
Yes, I just wanted to check that you had received a joint letter, a letter that was sent by the council, but on a joint basis, went in on the 15th in order to explain the position in relation to the section 106, because that, as I understand it, is a sort of joint statement as to where we are, which points are outstanding, and provides, I think, a helpful list of the points which are still in play.
I'm just bringing up my emails. I'm pretty sure I have seen it. Yeah, a letter dated 15th of
That's right.
July.
And I won't, if you've seen that letter, I won't summarise its contents at any length, but it does confirm that the advanced draft is in substantially agreed form. Those issues which remain outstanding are listed there. But yes, good progress is being made.
Okay, and that's a joint letter, is
That's
it?
my understanding. It was agreed.
Yeah, agreed. Okay, that's helpful. Okay, thank you. Okay.
If I may, just on the conditions, just to clarify that there's only one condition on both, it's the same condition on both sets, which is in disagreement. So whilst that table does look quite lengthy, it does explain the story of where we've got to. But once we give you the clean version, there will only be one condition for both where we're in disagreement, and therefore we can confirm all pre-commencement conditions are agreed.
Okay, thank you. Thank you. Okay, I think if you can just keep me posted in terms of the obligations as that happens, but it's good to know it's all sort of in hand and imminent, so it's helpful. Okay, and if I can set a deadline for the final draft, Thursday the 4th of August, plus the SIL compliance note as well. That would just be helpful for me.
I'll be okay to assume execution following, so within 10 working days or something.
Yeah, well, I'll set a deadline for the signing of it after the session, just in case anything crops up or needs to change. Okay. Do we have a draft timetable that's been circulated? I've got a paper copy. I'm hoping others have as well. We've got 14 sitting days, and it is very comfortable, which is good. We're not trying to cram everything in, especially if we do have tech issues or anything like that. It's always helpful. We've built in overspill days as well, so next Thursday, and as I said in my covering email when this was issued, I don't intend, if we don't use the overspill day, I don't intend on sitting that day and bringing anyone forward. I think we've got 4 weeks. It's quite a rest is always welcome, and we can take stock and prepare. So I'm hoping that's okay and there's no issues.
This is the best timetable I've ever seen. It's great.
Oh.
It's great because we've got time to do things without rushing and all that business. And if we don't need a particular day, then we won't be here. So
yeah. No, it's
not so month.
Entirely agree.
Yeah, no, it's learnt this from Bristol Airport, sitting 13 weeks. It was a marathon, so it's always good to have a few days off. But no, thank you to the programme officer for compiling that as well. Okay. Yeah, and usually we'll have comfort breaks and lunch breaks. If we need longer lunch breaks to do work or anything, we can accommodate those. If you need additional breaks because of the heat or for any other reason, let me know. After today, we'll start the inquiry at 9:30 every day. I do not intend to sit any later than 5 o'clock on any day, but earlier is always preferable. And just the usual caveat about cooperation with timings, and I will be reminding parties if you're reaching the end of your allocated slot. Okay, but I'll come to this later. Yes, so this is a blended event. I think it's the first one that the council have hosted. I think everyone's actually scheduled to sit and be here physically, the witnesses present in the room, unless something happens where we don't need to. But hopefully it will be seamless. I think there's a test event last week that the council held. So assuming everything works okay, it seems to be okay to me. So, but we'll just have to see. If there are any issues, concerns with the technology, just please let me know as soon as is convenient. Okay. I'll run through the procedure then. So I'll talk about the physical procedure, and then if I'll go through virtual just in case anyone is going to appear virtually as well. So I'll conclude my opening remarks today. Then we'll invite the Appellant Council and the Rule 6 Party, Historic England, to make an opening statement. This is just to set the scene and allow everyone to understand the main arguments. If any interested parties do attend today, we'll hear from them. And then this afternoon, we'll move on to a roundtable discussion about servicing with Transport for London. This will be led by myself, so no cross-examination. And I'm hoping it's not going to be an overly lengthy session, and we'll have an early finish, which in the heat is good. Tomorrow we'll have an introductory session for the schemes made by the scheme architect, and this was discussed and planned at the case management conference. I know there was some concern last week regarding the content of the presentation which was shared. And it's not an evidence-giving session, but I felt it helpful to me just to set the scene because we've got two quite different schemes in play, plus the list of building applications as well. Just on the presentation, I'm hoping that the concerns have largely been resolved. I know there's been some slides removed. From
just say a few words before mine in front. Thank you.
Yeah.
So, ma'am, that's right. We received some correspondence, I think, joint from the Council and Historic England, raising some concerns. I mean, obviously, neither Council nor Historic England, for understandable reasons, have heard the presentation. So, they're perhaps rather concerned that it might spill over from fact into all sorts of other matters. So all I can do is to reassure you that, as best as I can, that Mr. Alford intends to stick as close to facts as he can. I wanted to raise this myself, so I'm glad you've come to it. We did, in response to the letter, remove a few of the slides which were proving to be contentious. I won't say anything about that. They've been taken out, and so there you are. I intend for the presentation to be an explanation of the schemes, all although there are a lot of slides, I know that Mr. Walford, will be going through them at a fair pace. I know that he wants you and others to come up to the model so he can explain how certain aspects work by the use of the models. My concern, I do have a concern, which I just want to raise now, which is that I really don't want the presentation to be interrupted by all sorts of objections and so on and so forth. If there is anything that he says, Mr. Alford says, I hope there won't be, but if there is anything that he says that proves to be, I don't know, in some way contentious or whatever, then obviously he can be cross-examined about those points in due course. To be quite frank, I'd rather not do it than do it with interruptions and interventions. I'd rather just leave him until he gives his evidence in, a week's time or whatever, and he can do his presentation then. So I'm hoping that we will work on the basis that he'll just get on and do it. And I hope this won't arise, but if there's anything that arises that my learned friends consider, well, it's crossing the line, then they can ask him questions about that in cross-examination later on. I really don't want interruptions where, I don't know, if someone says this, I respond to it, they respond, you then say something, and the flow of it's completely lost. To be honest, I'd just bin it. I'd rather just not do it if that's where we're going to be with this. So I was a bit concerned when I received the letter last week, but we have taken some slides out, and I have done my best to make sure that this is a factual presentation. So I'll just say that. But if there is any concern about this, if we're going to get interruptions tomorrow, then I'm just not going to do it. We just won't do it, frankly.
Okay, all right. If I come to Mr. Philpott, and then I'll ask Ms. String as well.
Thank you. As you might have anticipated, that the purpose of putting in our concerns in writing well in advance was precisely to avoid the need for interruptions, for raising points on the day, for having to raise points afterwards. The idea was to ensure that the presentation remained within the limited scope that had been set out at the case management conference. The concerns that we raised were explained. I understand that they have been taken on board. I certainly hadn't intended to interrupt Mr. Alford as he was going along. No doubt there may be some elements which I might want to ask about in due course, but I'll have an opportunity to do that. But the whole idea of raising the points in advance was to give the appellant the opportunity to reflect on whether there was anything that might be excised or moderated in the way it was presented, to avoid stepping over the line. And I understand that changes have been made. I'm grateful for that. But I don't think my learned friend's concern is going to manifest itself. I don't intend to interrupt. I'll have my opportunity.
Okay, thank you. Ms. String.
I don't have anything to add to that.
Okay, and just so I'm, you have seen the new slide deck, and you're largely content with what that contains now.
So far as there is anything in it which is contentious, I'm content to ask questions about it in due course. Okay. I understand what my learned friend has said. I'm sure he will be doing his best to ensure that it stays within the correct boundaries, and I don't need to say any more about it at this stage unless there's something specific you want me to deal with.
Okay. Well, I'm happy to proceed because I do want to hear it just to set the scene. So I'm happy that there's been resolution since the letter last week, and like as has been said, you would have the opportunity to cross-examine in any case if there is any straying, but I'm confident that can be avoided anyway in the light of the presentation. Okay, thank you.
And I'm grateful to my two learned friends, so thank you, ma'am.
Okay, thank you. Okay, so well that'll be tomorrow morning, and then there will be an accompanied site visit after this session to the listed terrace. Who's going to be coming along on that site visit?
Yeah, so we'll have Simon Alford accompanied by one of his colleagues from AHM, Hayden Thomas, and also Peter Stewart, who's our heritage witness.
Okay, and for the council?
It'd be Dr. Barker Mills.
And for Historic England?
Alice Young will be attending. Madam, I don't know if it's a convenient point because I wanted to raise an issue about site visits generally in the timetable, because I know you were intending to do some visiting yesterday, but I'm assuming that you might not have managed to perhaps do as much as you would have hoped.
No, I was going to come to that. No.
And also we'd noted that the full sort of site visit was programmed to be for the 5th of August, which is obviously after all of the heritage evidence. Obviously there are, you know, I suppose pros and cons to either visiting before or after the heritage evidence. I suppose we were just wondering whether you felt it might be more useful to do the site visit before the heritage evidence, or to do perhaps some more of the site visit in the local area tomorrow. But it may be that you deliberately wanted it to be after the evidence so that you could see things and reflect. So
yes,
we just wanted to, I suppose, raise
yes, no, thank you. So yes, yesterday I had intended on doing quite a thorough site visit to following the itinerary that was provided to me, to sort of lots of the local area and the wider viewpoints as well. But given the heat, I did have a nice drink in the George pub. But so I've seen the site, I've seen the sort of local area, I've seen the sort of cathedral and some of the more local heritage assets. I've had a wander down Borough High Street, but I didn't do as full a visit as I had intended because I would have collapsed, quite frankly. I mean, the one good thing about summer inquiry is we have the late nights and the light, so I'm content that I'll be spending my evenings, not today, but the rest of the week, doing the wider unaccompanied visit. So I think if we just stick to the programme, but rest assured I will have seen what I need to see before the evidence giving, if that gives comfort to parties. I had wanted to do it yesterday, I just couldn't, but I will do my best. Okay.
So thank you for the terrace that you're visiting tomorrow. There will also be the on-site building manager who has to sort of open doors and so on. So it's not part of any team, but someone needs to lead the little tour. So, ma'am, what about seeing the other parts of the site itself on site? Because obviously it's not public. And would you be intending to? I mean, I would certainly welcome you seeing other parts of the site, not just the terrace.
Yes, well, I was going to ask that actually. Yes. So yes, I mean, tomorrow, given that we'll be getting access into the terrace, can we do the wider sort of building as well?
I'll just check, because there's the internal courtyard, etc., etc. Can I just check?
Yeah. Oh.
Oops.
Okay. Yeah, we'll chat about that this afternoon. Thank you. Thank you.
No problem at all, ma'am. Tomorrow you can add on the rest of it if you like. I mean, I think it would be personally a very good idea for you to have I'm sure everyone would agree, to have a good understanding of how the site works, which isn't just the terrace, obviously. So thank you, ma'am.
Okay, thank you. Okay, that seems sensible. And are there any health and safety issues? It's going to be cooler tomorrow, which is good, but are there any
it's going to be way cooler. No, I mean, it's a working building, so you'll hopefully see people at work inside it, so you're absolutely fine. I mean, I've been round and survived the experience, ma'am, so hopefully you will as well.
Okay, that's all right. I just have to ask, but it didn't look like it was a derelict site with pigeons everywhere, etc. So, okay. Okay, just then going back to the procedure. So after the site visit on Wednesday, Thursday we'll start with the formal examination. That's on a party basis, so it will be the council first, then Historic England, and then the appellant. Each witness will be cross-examined by the opposing side. There may also be some re-examination of the witnesses by their own advocates. I will generally ask my questions during evidence in chief or after cross-examination. I try not to interrupt unless I'm getting completely lost. So if I am lost, if I'm interrupting, take note. Okay. Once we've gone through all that in a few weeks, we'll hear a discussion on conditions and obligations, as we've referenced before. We'll then have closing submissions from the council, Historic England, and then the appellant last. If any party intends to make an application for costs, this should be done before we close the inquiry. If applications are to be made, as much notice as possible, please, and a written copy would be appreciated. I probably will deal with any claims entirely in writing, because it's I'd rather spend the time actually on the evidence giving, but we'll cross that bridge if we come to it. Okay. And then just so the room layout, so we've got witness tables either side, so we're not going to be playing musical chairs and furniture removal, which is good. So you'll sit your respective sides. Any questions on procedure, Ms. String?
It's not really a question on procedure. It's been brought to my attention on the day that we're programmed to present our case, which is the 27th of July. I understand there's a train strike for that day. And based on previous train strikes, it seems unlikely that would be cancelled. But obviously we've got an overspill day programmed in for the following day. So I suppose if that were to materialise, if that does go ahead, our day would shift forward.
Or will they be travelling on that Wednesday? So
I think we'll all be here.
You're okay. Okay.
Yeah.
Okay, so is it anticipated that if there is a train strike, there would be difficulty? I'm staying down the road, so it's not going to affect me. But obviously, I know people travel in and.
Same for us.
Yeah, I mean, certainly. Yeah, I think there would be potential. I mean, I would probably find it quite difficult to. Yeah, I'm not saying it's impossible, but yeah, it'd be difficult.
Okay.
And
manage. Okay, and in terms, because we are blended,
yeah,
would you be willing or to appear virtually, cross-examine, etc., well, examine virtually, or would you wish to use the overspill day instead?
I think default preference, given that everybody else is in the room, would be to be in the room.
Yeah.
It may be that it can be dealt with by, if it was perhaps a later start, that might make it easier to find alternative ways of getting in.
Okay.
Perhaps we can sort of revisit it nearer the time. I just thought I'd raise it at this stage.
Yeah. Okay. Thank you. So, did you want to say something, Mr. Philpott?
No, ma'am.
Oh, right. Sorry. I you seemed sort of hovering over the microphone.
No. I've heard what's said, and we'll see what happens. Let's hope there isn't a train strike, but it does seem.
Yes. Yeah. No. And thank you for reminding me. I had noted it, and I'd forgotten to include it in my opening. I think we'll just have to see how we go, and I think if you can just advise, but we could quite easily swap the Wednesday for the Thursday and the overspill day. It doesn't sort of fit quite as neatly in terms of finishing off examination for yourself, but we'll do what we can.
We'll be here on the Tuesday, won't we? So
yeah. So
we can sort things out then, really.
Yeah. Okay.
I'm hovering only because I wanted to talk about a couple of bits of paper, but is that later, ma'am?
It is coming, yes.
Right. I shall de-hover.
Okay. Thank you. Okay. So if anyone does participate virtually, it will be via Microsoft Teams. It's the usual. Ensure your microphone's muted, camera switch off unless you're speaking. The Teams link would be issued via the programme officers. So if anyone does wish to appear virtually, please let Mrs. Vincent know. And I'll go through it, I think, more if we do have someone in Teams rather than setting it all out now. And the session is also going to be live streamed via the council's YouTube channel as well, and accessed through there. And the recordings will be on there as well, which I always hate. Just a note on conduct then. So, we've got about 4 weeks. Inquiries are a marathon and not a sprint. It is comfortable in terms of the timetable, but let's not fill it unnecessarily if we don't need to. just to the witnesses, it's your duty to assist the inquiry with matters relating to your expertise. So please answer questions clearly, stating yes or no, and then qualifying your answer as necessary. If you don't know the answer, please say. If you don't understand the question, please ask for clarification. Don't answer what you think was asked or shoehorn what you think you'd really like to say in answer, because it helps nobody. Please be audible in your responses. Please be direct and concise to your questioning, and please ensure that you're set up and comfortable. If you wish for a break, let me know. Bring water, bring whatever you need to make yourself comfortable. And then to the advocates, not teaching you to suck eggs here, you're familiar with your duties, but brevity in submissions, courtesy in dealing with witnesses. I had last year at Bristol Airport inquiry, the council's advocate stated that he would put a question to the witness twice, and if they were being elusive, they just moved on and made written submissions, which I quite liked. I'd not seen that before, so I would encourage you to think about.
Yeah, I hope you're talking to the other side of the room, ma'am.
Well, I've not had any of you before, so I'm not familiar with
stopping it twice now. So whoever my learned friend was, thanks very much, but no thanks.
Well, I liked it. Okay.
Might have been Reuben Taylor.
It was, yeah, Mr. Taylor. It did work well, but I'll leave that one there. And I urge direct questions to witnesses. If I think you're covering established ground or badgering, I will ask you to move on. Please try and stick to your timings as much as possible. I will be reminding you in your examination. They are all on the timetable as well. I always put them in on there just so it's in black and white. And it can be helpful to provide a list of core documents that you wish to refer to ahead of the witness starting. I know it's not always perfect. You might wish to draw up another one, but if we have a list so that electronically I can have them up on my screen, it just makes things a bit smoother and less clunky. So I would encourage you to do that. So site visit. So we've gone over some of this already, but yes, I didn't make it out to all the points. I will try and do that this week when it's cooler to do that. And then tomorrow we've got the visit to the listed buildings and the wider site now, which will be helpful. And that was scheduled in purposefully before we hear the evidence, just so I'm familiar with the site, and I will be familiar with the surroundings as well. There'll then be a wider site visit scheduled Friday the 5th of August. And that will be accompanied. We'll discuss that closer to the time, who's going to come along to that and guide me around. Obviously, just a point on site visits, it's not an opportunity for you to have my ear, give evidence. You can point out factual things. Again, I'm sure everyone's familiar with it, but it's just good to note and say. I would also find it helpful if I can actually view the site from the Shard and have a look from an elevated position, and that wasn't in the itinerary. So I just wanted to explore that with parties now, if possible, if anyone has any views on that.
You'd need to go up to the public viewing galleries at the top of the Shard, ma'am, but I mean, that's needs to be paid, so we'd presumably have to...
Well, I'll try and put it through our expenses and see. I don't think there's a thing on our computer program for it.
It's one of those things I know. Sorry, you're talking about my favourite building, by the way. So for various reasons, but I know that the way it works is the closer you book, the dearer it is.
Right.
So the sooner you book, the better.
Okay. Okay. I'll have a look into that then over the breaks and perhaps advise. Have you any comments on that from either of you, Mr. Philpott?
No, if you'd find it helpful, certainly no objection to going up and seeing it from there.
Okay.
Likewise, madam.
Right. Do I need to be accompanied then, given there's a costing, or I can just go at myself at my own leisure?
It's really nice like that.
All right, that's fine. Okay, thank you. Okay, in terms of plans then. So there's a great number of plans for each scheme. I'm not going to list them here because, again, we'd be all day. I think, was there an issue in terms of the 2018 set on the core documents list in terms of the labelling? I thought that been an issue. No?
We're aware of, ma'am.
No. Okay.
You have got a book of each.
I have. Well,
yes.
part of the course has got my book
with your
of
shoes.
plans. Yeah.
With your shoes.
Yes. Yeah. I was going to take it as it's as listed on the draft conditions and as has been produced in my book of plans that will hopefully be winging its way to me shortly again. So okay. Documents then. So all core documents and evidence should have already been provided. The core documents list is now closed. Any further documents will be marked down as inquiry documents and they'll be put on the website as those. I or Joanna Vincent as programme officer will assign a reference number to those just to keep track of it, because if we've got three different parties here and it tends to balloon and the same document numbers being assigned to different documents. Does anyone intend to submit any further documents at this stage?
Can I, before I get a couple of, there are only two from our perspective, get those off my chest. I know that recently, I genuinely don't know whether pins were copied in on this correspondence, but I believe the council wanted to add a recent Secretary of State decision, the Edith Summerskill House decision. As far as we know from checking yesterday, it hadn't made it to the core documents, perhaps because of the point that you've raised. As I wanted to add it to my list that you've asked me to compile of documents for cross-examination. I just wondered whether I could just understand where it is. Is that now an inquiry document as opposed to a core document, or?
CDH20.
H20 it's become, is it? Lovely. Okay,
I was going to say, I thought that one did make it onto the list.
As of yet, well, maybe I was looking at the wrong thing, but anyway, okay. That's not a problem. Great, so I know which one that is. And then two documents I just wanted to mention, ma'am, and I imagine there'd be inquiry documents. Now, first of all, there was that a brief written response to Mr. Platt's statement that you've accepted in as evidence. So, as I said, that's not a problem from our perspective, but we just wanted to, as far as we're concerned, correct the record on a few points. So, ma'am, that's one document that would be submitted. I assume we should do all of this electronically, I suppose?
Yes, please. And
thank you.
I think I would appreciate a paper copy of inquiry documents just so I've got.
And would you like that now, or in a moment, or
not yet, but yeah,
through the programme?
If you do it through the programme officer, because what I'll do, I'll give the openings and inquiry document reference, and then the ones after that.
Yes, we don't want these to jump the numbering system, that's for sure.
Yeah.
And then the other document is, ma'am, that you mentioned when you went through various representations that have been received vis-a-vis the appeals, that one of them was from the Cathedral's Fabric Commission. And I don't know whether you had an opportunity of reading that yet.
I skim-read it last week.
Right, thank you. And you perhaps would have seen that they raised some queries about the wind modelling that had been done.
Yes.
And we have a written response from our wind modellers in relation to that.
Okay.
Because we couldn't, I was going to say leave it hanging in the air, but that would have been a very bad unintended pun. So we couldn't just leave the statement without putting a response into it. So
okay.
So that's it. Those are the two statements. So we're give hard copies to the programme officer, and there'll be inquiry documents in due course, or someone will tell us the numbers in due course.
We'll sort
Thank you very much.
Okay,
that's me done.
Okay, Mr. Philpott. I mean, so just picking up on the written response to Mr. Platt, have you seen that?
No, not yet.
No. Okay. I mean, I'm content to accept it. It's quite unusual to have a rebuttal effectively from a non-witness, but I don't want sort of rebuttals and things tennis going forwards. If there are any questions arising from it, obviously you can put anything in cross-examination.
Exactly. Okay? No, I'm content that to go, and that was our understanding of how it's going to be dealt with. And I assume from what's been said that it's proportionate, and we'll see it when it comes in. The only documents that I just wanted to raise at this stage, I believe you, and therefore the parties will already have them, but I don't think they're core documents. These are the responses to each scheme from the Conservation Area Advisory Group. I understand they came in with the package of materials, 2 pins, but I don't believe they're core documents. And because the impact on the conservation area is an issue, it seemed that it might be sensible to have those available to refer to. And they would now go in, I think, as inquiry documents if they're not already.
Okay, so they're definitely not in core documents. So I say the list's closed, but the home for them might be better as a core document.
Yes, they would sit naturally, because there is obviously a section dealing with internal sort of responses and so on.
Yeah.
And I'm entirely agnostic as to where they go. I'd be happy for them to go in the core documents, but it would seem sensible to be able to refer to them, and so they ought to be added in somewhere.
Yeah. Okay. I think, can you send those and liaise with the programme officer? So happy for those to be core documents in a sensible location. I'll let you lots sort that out between you.
We'll handle that.
Do you copy us in? When
of course, yes.
Yeah, I mean, just as a matter of course, if there are things being sent in, if you can just copy the other parties in just for information. Okay, right. Okay, and Ms. String, any?
Nothing for me, thank you.
Okay, easy peasy, great. Okay, thank you. Yeah, I mean, if during the course of the 4 weeks that we have, if anything needs to be submitted, obviously it comes through me. It's helpful if any party's intending to submit anything, if you can have a chat between yourselves, so it's not a surprise, and we can have a discussion if there are any issues, or if you've all agreed it, that just makes it a little bit easier. Okay. And just a comment, when sending Programme Officer Joanna Vincent documents, just please explain what it is, because rather than just sending an untitled or something that's a bit cryptic as to what it is and where it should be. Okay. I'm not going to treat the conditions and obligations documents as inquiry documents yet, because we'll end up having versions and versions and versions, I'm sure, and it just sort of clogs up the inquiry documents list. So we'll keep a sort of a separate eye on those, and then the final versions will be formal inquiry documents. Okay. Okay, nearly there. Matters I just wish to raise up front now. Obviously, there are four separate appeals here linked. We just need to be really, really clear which scheme we're speaking to, so I don't get confused, nor do the witnesses and anyone else in the room. In terms of the listed building applications, obviously council supplied putative reasons for refusal on these. I just noted that very little had been said in the proofs and in the heritage statement of common ground. I just wanted to clarify the position on the listed buildings, just so I'm clear.
Yeah, my understanding is that the refusals, or the position related to the listed building appeals, is essentially parasitic on the main planning appeals, in that the concern is not so much the listed building works themselves. It's that if there isn't an acceptable scheme for redevelopment, those works shouldn't take place without forming part of a wider scheme. So I don't understand there are separate objections beyond that parasitic point to the listed building appeals, and that's why they're dealt with relatively lightly in the material.
Okay, because I have the statutory duty under section 16 of the Act, so I need to be really clear myself in any case. So I just wanted to understand that. So that's helpful. And the visit tomorrow will also sort of clear some things up, I'm sure. So thank you for that. And then I did note in my scan of the conditions, there's the BREEAM issue. I think there's an issue about the compliance with the level of BREEAM. BREEAM. So that, yeah, that's probably. I'm dyslexic, so I tend to have my own. So no. So it's fine. I just have my own sort of little quirks and say things, but feel free to pick me up at any point.
I learned English as a foreign language, so we'll be fine then. So, yes, those are. Is this the? Is this the one? Would you like Miss?
Well, no, I don't need to hear about it now. It's just I know there's a difference there, and I didn't know if there are any implications in terms of the listed building works that might have that I might just need to be clear on.
I don't think so, Mum. I think they where we are, as I understand it, in relation to BREEAM conditions, is there's some further material that's been submitted. And I think the council are considering that, and I'm hoping perhaps the issues will narrow a bit. Is this, or have I got this completely wrong? I've probably got it completely wrong.
No, it's largely correct.
Coming from you, that's a huge compliment.
Thank you. I think it's true to say that one of the reasons that we can't commit to the higher level of BREEAM for the Georgian Terrace is because the plans and the application that are before you, which align obviously with the application for listed building consent, reflect the most work that we think that we can do in order to target the very good level of BREEAM. If there were a way to increase that target up to the excellent, which the council is currently still considering, because my understanding is that they're still looking at the information that came in with the rebuttals, which had a bit more information on BREEAM. I suspect that if changes were required, the drawings would need to change, and the listed building application before you would be different. So the drawings and the works included have always been targeting a very good level of BREEAM, which is the furthest that we think that we can achieve in that building with the historic fabric.
Okay. Did you want to come back?
No, there's nothing I need to come back on. The understanding is that we are considering those further materials. That's my understanding as well. And the nature of the issue, I think, is yes, what can be achieved, and therefore what's the right target.
Okay, and then so in terms of obviously we've got examination with heritage witnesses. Is that going to be picked up with them, or is that going to be left more for the conditions? So I'm quite content either way. It's just it just needs to be aired, doesn't it? So
it seemed to me it was for the condition session. I mean, if there is by that time, we say we can't go further than this, and if it is the position the council says, well, we think you can go a bit further, then presumably whoever the relevant people are who need to speak to that could attend the condition session for that part of the discussion.
It seems to me that the condition session is probably the appropriate way to deal with it. I don't think at the moment it's likely to be something that requires heritage evidence per se. I may be corrected, but that's my current understanding of the position.
Okay, that's helpful. Thank you. Okay. Okay, and then other matters have been raised in terms of wind effects, which we have discussed. Daylight, sunlight, Borough Market, light into the chapel at Guys. We're not going to obviously specifically cover all those. It's just they've been raised by interested parties. So you might need to pick them up in planning sessions or in closings as well. So just to highlight that.
Yes, indeed. I mean, in relation to the chapel, I think from memory, Historic England might say a bit more about this than Dr. Barker Mills. It might be the other way around, but both witnesses on the other side of the room, so to speak, mention they draw attention to the point. We've responded to it, and also you had, prior to our response, you had an assessment in the event. So I had sort of thought that I would sort of raise the point somewhere along the line in cross-examination, but anyway, it's in relation to, because it's a heritage point. Yeah. It's not a light per se, if you like. Point. Yes.
Yeah. Okay.
Yes, I think so far as we're concerned, our daylight and sunlight evidence is contained within our planning proof, and it's dealing with assessments which are not in dispute in terms of the technical output.
Yeah. Okay. Did you want to say anything? No. No. Okay. Thank you. Okay. Okay. Are there anything else that parties wish to raise now? Oh, no. No. Okay. All right. That's it for my opening remarks even this morning. What time are we on? So we've got the openings. Sorry.
Did you mention a break, ma'am?
Well, I was just coming to that. Shall we take if we come back at 11:30 and then we'll commence with the openings? Okay, thank you. phone, there's a volume button. So can I ask that that's turned up just so we can make sure everyone can hear? And if you can speak into the microphones as well, that would be appreciated.
Oops. Okay, this is the old-fashioned way. So wait a minute. So you turn this, swiveling this thing. So is that? That's at one end of one end of the thing. So I don't know whether that's loudest or the quietest it gets.
Can we hear okay?
That's much better. I think the.
No. That I know I can solve that one. The microphone's set for 3, Pete. So 3 can have it turned on at once, and if a 4th person joins in, it flashes green, so you're waiting. So there we go. Okay.
Slight issue. That does seem to be louder, doesn't it? I can hear myself more, but which is a bad thing. But the only slight thing about having these things in front of you is that when you're working and cross-examining or taking an evidence in chief or whatever, it's we can't. But I don't intend to sit here like this, to be quite honest.
We'll just have to sort of try our best with the mics. Do you want to test yours?
Can I be heard? Touche.
Okay, all right. If there are issues with, if you can't hear at the back, just sort of raise a hand and we'll try and do what we can. Okay. All right. Okay, so we're now on to the openings. I don't know who wants to go. I never mind. And everyone seems to want to do things differently. So
you tell us what you would prefer, ma'am, and that's how we'll do it, if that's okay. Whatever way around.
What's on the schedule?
On the schedule is me last, which
Okay, we'll stick to the schedule then. So, Mr. Philpott.
Thank you, madam. I've got a note which I'll have handed round.
Thank you. So these will be inquiry documents. Thank you.
Are you content for me to start?
I am, yeah.
Thank you. So by way of introduction, the appeal proposals seek to introduce a prominent tall building into a sensitive location within the Borough High Street conservation area, the setting of the Tower of London World Heritage Site, and a large number of other heritage assets, and the London skyline. 2 quite different tall building proposals, each comprising an application for planning permission and listed building consent, are before the inquiry. The principal element of the 2018 scheme is a 37-storey tower at 144 metres AOD. For the 2021 scheme, the main component is a 26-storey tower at 108 metres AOD, which, although lower than the 2018 scheme, delivers a similar quantum of floor space through its greater massing. In spite of the differences in their form and design, each proposal would have a significant impact on the local and wider surroundings. Alongside the tall buildings, each scheme would deliver new public realm, an elevated public garden, a new access to London Bridge Underground Station, and the restoration, refurbishment and rebuilding of the Grade 2 listed Georgian Terrace at 416 St Thomas Street. The significant potential impacts of new tall buildings and the need to actively manage this impact fall to be addressed through the detailed framework set by the London Plan and the Southwark Plan. This framework requires consideration of the effect of tall building proposals at ground level, within the immediate and wider townscape and skyline, including in relation to strategic and borough views, and on the capital's heritage assets. Whilst the appeal site sits within the broad area identified by the Southwark Plan as potentially suitable for tall buildings, that does not mean that the site itself is necessarily suitable. There will be many sites within that broad area that are wholly unsuited to such development, and site suitability must be assessed against the criteria set by policy. The management of new tall buildings across the borough, including at London Bridge, was the subject of recent consideration by the London Borough of Southwark, the Council and the Inspectorate through the preparation of the Southwark Plan, which led to 4 site allocations, not including the appeal site, at London Bridge, along with a general requirement that new tall buildings maintain the primacy of the Shard and its status as a pinnacle and landmark. The Council's case is that the appeal proposals fail to accord with the requirements set by the London Plan and Southwark Plan. Both the 2018 and 2021 schemes are in conflict with the development plan overall, and that conflict is not outweighed by the public benefits of the proposals. The appeals are for non-determination. In respect to the 2018 scheme, the Council and appellant engaged in a pre-application process between August 2015 and November 2018 before the applications were submitted in December 2018. The Council's pre-application response letters were not supportive of the scheme, identifying an insensitive approach to a number of heritage assets of the greatest order of significance, a substantial and harmful impact on its sensitive historic setting, which remains unjustified, the proposed tall building's likely isolation from the London Bridge cluster, and the scheme's failure to comply with the locational criteria of the then extant Southwark Plan 2007 in respect to being situated at a point of landmark significance. The application was subject to various modest amendments, but in October 2020, the appellant wrote to the Council requesting that the assessment of the 2018 scheme be put on hold while they progressed an alternative scheme, the 2021 scheme. Following a pre-application process between October 2020 and April 2021, the applications for the 2021 scheme were submitted in April. The Council's pre-application response to the 2021 scheme was, as with the 2018 scheme, not favourable. It explained to the appellant that the reduced height, which is accompanied by a significant increase in bulk of the building, does not overcome the principal concerns expressed in relation to the 2018 scheme, particularly on the harm to the townscape, the conservation area and setting of a large number of listed buildings, and would not be supported were it to be formally submitted. Appeals were lodged in January 2022. PIN's timetable for the appeals necessitated the preparation and issuing of the Council's statements of case in advance of the next available planning committee. A bespoke planning committee was organised for the 19th of April 2022, at which the statements of case were considered, and members unanimously endorsed the likely reasons for refusal, which are common to both schemes. And they're summarised as follows. First, the proposed development would give rise to less than substantial harm to a number of designated heritage assets, including the outstanding universal value of the Tower of London World Heritage Site, Grade 1 listed Southwark Cathedral, Grade 1 listed St Paul's Cathedral, Grade 2 star listed Guy's Hospital, and the Borough High Street Conservation Area. The harm is not outweighed by public benefits, and that's reason for refusal 1. Secondly, the proposed development's scale and design is not appropriate for the site and its surrounding context, resulting in harm to the townscape and local character. As a result of this harm and the harm caused to heritage assets and its relationship to the local and wider context, the proposed development does not constitute good design in context and would be contrary to development plan policies and to national planning policy on achieving well-designed places in the NPPF. That's reason for refusal 2. And then thirdly, in the absence of a completed Section 106 agreement or unilateral undertaking, the proposed, that should be proposed rather than proposal development, fails to secure appropriate planning obligations to mitigate its adverse impacts and secure the public benefits of the proposal to ensure compliance with planning policies for these topics. In respect of both schemes, although not advanced as a likely reason for refusal, the Council's case is that the impact of the respective proposals on daylight surrounding residential and student housing properties, sunlight to nearby residential units, and overshadowing of the proposed public realm within the site are material considerations that weigh against the schemes in the planning balance. In respect to the 2018 scheme only, the suitability of the servicing arrangements proposed is, in the absence of resolution of the outstanding issues with TfL, a further factor identified as weighing against that scheme in the planning balance. With regard to the listed building consent applications, the Council supports the majority of the proposed works to the listed Georgian Terrace. In respect to the 2018 scheme, the Council considers that the introduction of shop fronts at the rear of the listed building would result in less than substantial harm at the lower end of the scale, but that this would be outweighed by the wider package of public benefits through the works. The Council considers that permission should be refused for the listed building consent applications because, in the absence of an appropriate planning permission for replacement extensions and external elements that would ensure the buildings are made weathertight and rebuilt in accordance with an appropriate scheme, the proposals fail to safeguard their special architectural and historic interest. The issues that arise from the reasons for refusal will be addressed by the evidence of 3 expert witnesses on behalf of the Council. Dr. Nigel Barker-Mills, Barker-Mills Conservation, will provide evidence in respect of heritage, the impact on strategic and borough views from the perspective of the historic environment. Miss Elizabeth Adams of Adams and Sutherland will address matters of architecture, urban design and townscape. And Mr. Michael Glasgow of Atkins will provide evidence on matters of planning and the overall planning balance. And he'll also participate in the servicing roundtable. The matters agreed between the Council, the opponent, and where relevant, Historic England and TfL are set out in the 3 statements of common ground we've identified there. These opening submissions provide an overview of the Council's case. They're structured having regard, Madam, to your identification of the main issues as follows. I don't propose to read out that list, it'll be familiar to you. So I then turn to the main issues, and first, the effect of the appeal proposals on the significance of designated heritage assets. As the evidence of Dr. Barker-Mills will explain, the impact of the appeal proposals would be overwhelmingly harmful. That harm ranges from less than substantial above the middle and towards the upper end of the range, down to the lowest end of the range for a large number of different heritage assets. The nature and scale of the impact is exemplified by Historic England's decision to participate in the appeals as a Rule 6 party. With regard to the approach to judging the level of heritage harm, the Council relies upon the approach that was endorsed by the Secretary of State in the Tulip decision, and before that, the Citron decision. In short, the decision maker should focus not on whether some aspects of a heritage asset would be left untouched, but rather on the importance of what would be affected, namely the setting and its contribution to the significance of the assets in question. This aligns with the approach taken in the Historic Environment section of the MPPG, which states that when contemplating whether works to a listed building would cause substantial harm, an important consideration is whether the adverse impact seriously affects a key element of its special architectural or historic interest. The Council notes, and has already drawn to Madam your attention, the recent decision of the Secretary of State in relation to a tall building proposal in the London Borough of Hammersmith and Fulham, and the inspector's findings in that decision as to the approach to heritage harm. It represents one approach to assessing harm taken by an inspector, but as the Court of Appeal stated in the Brams Hill case, the decision maker is not directed to adopt any specific approach to identifying harm or gauging its extent. In the recent decision of the High Court in the London Historic Parks and Gardens Trust versus Ministry of State for Housing case, the Court endorsed and reinforced the position adopted in Brams Hill, stating that it was consistent with the general approach taken by the courts in deferring to and respecting the expertise of planning inspectors and guarding against undue intervention in policy judgments within inspectors' areas of specialist competence. And with this in mind, it's the Council's case that the approach taken by the Secretary of State in the Tulip and Citron appeals is to be preferred, but it recognises ultimately this is a matter for your expert judgment, and then obviously in due course for the Secretary of State. The sensitive nature of the appeal site is apparent from its location within a conservation area, the number of designated and undesignated heritage assets both within the site itself and within close proximity to it, and its position within the settings of some of London's most important and iconic heritage assets. The location, height, form, mass, and visual dominance of the appeal proposals would result in harmful impacts on the setting of the Tower of London World Heritage Site and some of the Grade 1 listed buildings within it, Grade 1 listed Southwark Cathedral, Grade 2 star listed Guy's Hospital, the Borough High Street Conservation Area, and Grade 1 listed St Paul's Cathedral, including in the context of the London View Management Framework Strategic Views and Borough Views. The appeal proposals would additionally cause harm to the setting of a large number of other listed buildings, including 3 further Grade 1, numerous Grade 2 star and Grade 2 buildings, and 3 further conservation areas. And then I turn first to the Tower of London World Heritage Site. The Tower of London World Heritage Site is a heritage asset of the very highest significance and of international importance. As a consequence of its significance, it benefits from the highest level of policy protection. As the evidence of Dr. Barker Mills will explain, the relationship between the Tower of London and its setting is at the heart of the significance, or OUV, of the World Heritage Site, as well as being key to the ability to appreciate its significance. The location of the Tower of London on the raised topography of the north bank of the River Thames is a product of its original function of controlling and protecting the City of London. Unease about the management of tall buildings and the setting of the tower was first raised by UNESCO and the World Heritage Committee at the point at which it was put forward for inscription in 1988 and has remained a concern. The ICOMOF's mission report of 2011 raised a clear concern about the impact of tall buildings, both completed and permitted at that stage, indicating that the visual integrity of the Tower of London had been compromised by the Shard. The mission recommended that if any further tall buildings were planned, they should not exceed the height by which they would become visible above the on-site historic buildings that are part of the tower complex. The mission considered that any additional tall buildings in the area would destroy the visual integrity of the property and severely compromise its OUV, possibly beyond repair. The WHC regard the setting of the Tower of London as already eroded and as having potentially reached its limits in terms of the additional tall buildings it can accommodate without harm to the OUV of the property, and the Shard was regarded as a harmful intervention in terms of the OUV and the visual integrity of the Tower of London. Both the Mayor and the Council have recognised the importance of this impact, and as Mr. Glasgow will explain in evidence, the approach to development management in relevant policies in the London Plan and Southwark Plan has been tightened and made more robust so as to reflect and respond to this concern. The 2018 and 2021 schemes would introduce a tall building located to the west of the other recently consented or constructed tall buildings, Shard Place, Capitol House, Vinegar Yard and Beckett House, and would introduce a new development that would extend the visual intrusion of new development into the sense of enclosure within the tower and erode the degree to which it is visually enclosed within its setting, as well as having an impact on its visual linkages. Neither the 2018 nor the 2021 schemes would appear to be obviously part of a curated cluster, and they would appear visually detached from the existing group in important views, particularly from the eastern part of the inner ward. Both schemes would have further adverse effects, namely reducing the visual prominence of the Grade 1 listed White Tower and concentric defences by appearing as a distracting feature in the sky space adjacent and above the curtain walls as one progresses around the northwestern part of the setting of the World Heritage Site. This would exacerbate and add to the harm already caused by the Shard. The harm to the World Heritage Site for the 2018 scheme is fairly characterised as less than substantial harm, just below the middle of the range, and for the 2021 scheme at the low end of the scale of less than substantial harm. The protection of the World Heritage Site should be given the maximum weight possible in decision making. The harms caused by the 2018 scheme should attract very significant weight within the planning balance, and for the 2021 scheme, significant weight. Next, Southwark Cathedral, Grade 1. In approaching from the north across London Bridge, the cathedral is an important feature, and there is currently clear breathing space in the form of a corridor between the cathedral tower and the commercial buildings to the east, including the Shard. The corridor of space makes an important contribution to the appreciation of the cathedral. Both schemes would infill much of that space, challenging the visual prominence of the cathedral and eroding the contribution made by this part of the setting to the cathedral's significance as a heritage asset. Both schemes would also have a significant adverse impact on the experience of the cathedral in the areas of its setting immediately to the north along Montague Close and associated spaces, which presently enable the best appreciation of the architectural composition of the building. From Montague Close, the relative position and relationship of the 2018 scheme to the central tower of the cathedral changes as you move along the street and as you experience the cathedral within its setting. The cathedral tower can presently be appreciated against clear sky. The tall building in the 2018 scheme will be distracting and visually intrusive and will appear visually attached to the tower from certain viewpoints. The appreciation of the east end of the cathedral and the chancel, already harmed by the appearance of Guy's Tower, will be further harmed by the new tall building immediately to the right, and it would appear visually attached to the north transept of the cathedral, which is now its main entrance. As for the 2021 scheme, in the immediate setting of the cathedral, the tall building would present a considerable visual challenge to its prominence. It would appear in an extremely unfortunate visual relationship with the cathedral in views from the northwestern area of the setting, appearing immediately behind and visually attached to the central crossing tower of the cathedral. The increased width of the proposal in comparison to the 2018 tall building would result in the clear sky setting being lost, on both the east and western profiles of the tower, and the simple clarity of the silhouette of the cathedral being eroded. As Dr. Barker-Mills will explain, the harm to the significance of the cathedral arising from both the 2018 and 2021 schemes is above the middle and towards the upper end of the range of less than substantial harm. In light of the significance of the asset affected and the scale of harm identified, such harm should be attributed very significant weight. In Guy's Hospital, Grade 2 star, Guy's Hospital and the other heritage assets on St Thomas Street display coherence in terms of planning, materials used, and functional historic links. The quality of coherence associated with these buildings represents a positive contribution made by setting to the significance of Guy's Hospital and the ability to appreciate its significance. The quality of coherence is vulnerable to the intrusion of tall buildings into this area. Both schemes proposed tall buildings that would have little affinity with the consistent historic grain and character of this setting, which would be particularly harmful to the carefully balanced and planned nature of the hospital complex, including the quads. In particular, the relationship between the proposed tall buildings and the architectural formality of the entrance court would be extremely damaging to the significance of the Grade 2 star composition of the hospital. The buildings would also intrude into the experience of the closed quads or courts of the hospital to the south. The schemes would rise behind the central pedimented block of the West Chapel wing of the entrance court, but would be off the central axis and at an angle. This dissonant relationship would be further emphasised by the design of both schemes, which is particularly challenging to an appreciation of the classical architecture. For both schemes, the harm to Guy's Hospital is assessed as being above the middle and towards the upper end of the range of less than substantial harm. As with the weight to be attached to the harm to Southwark Cathedral, the harm to Guy's Hospital should be attributed very significant weight. Then the conservation area. The Borough High Street Conservation Area is one of the oldest in the capital, and that early designation reflects its particular significance. The character of the area is complex, reflecting its lengthy period of occupation in what is the original Roman suburb, unrivalled anywhere else in the capital outside the City of London. The diverse character and appearance of the conservation area includes places such as in the vicinity of the appeal site on St Thomas Street, where a consistent height and grain make a major positive contribution to significance. The conservation area appraisal identifies the St Thomas Street sub-area, sub-area 4, in which the appeal site is located, as having a particularly distinguished historic character, different to the frenetic commercial activity of the rest of the conservation area. The appraisal notes the restrained quality and consistency of sub-area 4's Georgian and Regency houses and the formality of the hospital and medical school buildings. Both schemes would have a serious adverse impact on the conservation area and would be entirely at odds with and damaging to the distinctive characteristics of sub-area 4. Each would introduce a tall building that is completely out of scale with the historic context into the heart of the conservation area. Each would develop what is in effect the rear of several buildings to introduce a monolithic building in a context in which the grain of historic development is characterized by yards or alleys flanked by buildings of subservient scale at the rear of the development that addresses the street. As Dr. Barker-Mills will explain, each would create a visually dominant landmark that would be seen in important views identified within the conservation area, and each would introduce a new visual focus when approaching from the south, challenging one of the most significant landmarks in the area, the Church of St George the Martyr. Further harm will be caused by removing the hop sampling rim facades on Kingshead Yard and relocating the facade of Keats House to non-designated heritage assets that meet the criteria for making a positive contribution to the conservation area. In addition, the introduction of significant gaps into the formerly consistent and coherent building line along St Thomas Street would harm the architectural qualities that makes this sub-area of the conservation area distinctive. As Dr. Barker-Mills will explain in evidence, the harm to the conservation area falls above the middle and towards the upper end of the range of less than substantial harm. It's appropriate to attach very significant weight to this harm in the planning balance. Then St Paul's Cathedral, Grade 1. New City Court is not in close proximity to St Paul's. However, the tall buildings proposed will appear within the setting of the cathedral, and it's the extent to which each of the schemes will distract, challenge, or erode the capacity to appreciate the cathedral or elements of its silhouette that is relevant. In respect to the 2018 scheme, the tall building would emerge immediately behind the northwest of the two towers of the cathedral and appear as a strongly vertical mass in views from the Kenwood gazebo, severing the visual connection between this tower and its backdrop. The visual competition and distraction arising from the new building would be harmful to the ability to appreciate St Paul's and would exacerbate harm already caused by Guy's Tower. The 2018 scheme would also represent a distraction to the appreciation of St Paul's from local views, especially View 1, north-facing view from One Tree Hill, and View 2, St Paul's Cathedral from Nunhead Cemetery. In respect to the former, the distraction would not be a serious challenge to the visual prominence of the cathedral, but from Nunhead Cemetery, the effect will be more pronounced. The tall building would immediately attract attention and visually challenge the cathedral as the dominant building in this view. The impact of the 2021 scheme on St Paul's will be reduced but remains material. With respect to the view from the north, the tall building will still exacerbate the harm caused by Guy's Tower by completing a circular development that visually isolates the dome from the western towers, and the effects in respect of borough views in the south would remain but will be reduced when compared to the impact of the 2018 scheme. Both schemes would result in less than substantial harm at the lower end of the range to the setting of St Paul's. By causing harm, the proposals would also fail to comply with the visual management guidance of the LVMF, as well as conflicting with policies in the London and Southwark plans that seek to protect strategic and borough views. Having regard to the significance of the asset and the scale of harm, significant weight should be attached to this harm in the planning balance. So far as the other heritage assets are concerned, the appeal proposals would result in less than substantial harm to a significant number of other assets, including those of the high significance. The evidence of Dr. Barker-Mills identifies and assesses the various other listed buildings and 3 other conservation areas that would be affected. His evidence considers a contribution that setting makes to their significance, which allows for an informed assessment of the impact of the appeal proposals. His evidence will also show the appellant's approach to assessing the impact of the appeal proposals on heritage assets is flawed in terms of the approach it adopts and the consequent quality and reliability of its analysis. So in conclusion on this part, the extensive impact of the appeal proposals can be appreciated by considering the number of assets that are adversely affected. Many are located in close proximity, some are at a considerable distance from the site. The wide extent of the impacts in this case is an illustration of why the development plan sets such stringent tests for tall buildings. A tall building on the wrong site will make its unwelcome presence felt far and wide. The heritage assets affected include iconic assets that represent the international identity of London as a world city, and it's notable that Dr. Barker-Mills' views regarding the level of harm that would be caused to key assets align with Historic England's assessment undertaken by Mr. Young. The status of Historic England as a statutory consultee and its specialist role mean that its views should be given considerable weight and only departed from for cogent and compelling reasons. Harm to designated heritage assets results in a strong statutory presumption against a grant of permission. As the evidence of Mr. Glasgow will explain, in this case, the public benefits do not outweigh the harm caused by either of the appeal proposals. The proposals are contrary to relevant policies in the London Plan, the Southwark Plan and the MPPF, and their impact engages a statutory protection, which requires that considerable weight be given to any harm identified. Then the second main issue, the effect on character and appearance of the area in regard to urban design, townscape, architectural qualities, skyline and public realm. As Miss Adams will explain, neither scheme represents good design appropriate in its context, and neither delivers the particularly high design and architectural quality standards required of tall buildings by the London Plan, the Southwark Plan, and the NPPF. Further and significantly, neither scheme accords with the detailed framework for the assessment of the acceptability of tall buildings in the Southwark Plan and the London Plan. For buildings of the scale proposed to be successful and introduce high quality design, they must be founded on a careful consideration of the suitability of the site and its context to accommodate such development. In this case, there has not been an appropriate assessment of what is distinctive about the appeal site and its local context. The design story presented by the appellant also lacks any explanation of how the existing built scale and conditions in that local context have informed the proposals to develop the appeal site with a tall building. In respect to the 2021 scheme, the appellant chose not to submit its proposals to the important process of independent design review, sidestepping the enhanced scrutiny expected by the London Plan of tall building proposals. Miss Adams' evidence will explain the distinctiveness of the local context, including its location in a part of London that is varied and complex, but where, in the immediate vicinity of the appeal site, the two sides of St Thomas Street, including Keats House and the Georgian Terrace on the south, and the old operating theatre museum and Georgian Terrace on the north side, there's a particularly strong sense of place. Both sides of the street work together to define a coherent spatial quality and consistent scale, distinct from the London Bridge Station and tall building cluster focused on the Shard. Current 6-storey 1980s building on the appeal site with its associated garden and roof terrace spaces is not striking in architectural terms, but its respectful and restrained character allows the existing Georgian Terrace and Keats House to retain their integrity and presence within the local context. In respect of the height, scale and massing of the schemes, Miss Adams will explain that each proposal fails to respond positively to local townscape character and context, including respect to the historic environment. Each of the schemes is of a scale, height and mass that would have an unacceptably and permanent adverse impact on the existing conditions and townscape qualities of the site. Each proposes a building footprint that is disproportionately large in relation to the land available and so restricts the possibility of creating high quality and generous public realm. The first two criteria of policy P17 of the Southwark Plan relate to the identification of acceptable locations for tall buildings. Miss Adams will explain the appeal site is not located at a point of landmark significance in accordance with the definition in the plan. It's self-evident from that criterion that not all sites within the council's area, including those that fall within the broad locations identified by the plan as potentially suitable for tall buildings, will be located at points of landmark significance. Further, neither proposal is of a height that is proportionate to the existing urban character, the significance of the location, nor size of the site. Instead, each scheme would constitute overdevelopment of the site. With regard to the architectural design quality of each proposed tall building, the standard required is exemplary. As Miss Adams will explain, neither proposal is exemplary in design, and nor does either meet the good design requirements of the NPPF and the National Design Guide. Rather than being exemplary, an appropriate descriptor of the design of both schemes is that they are incongruous in terms of their architectural language and expression. By drawing architectural references from warehouses and large engineered structures such as the nearby railway, the design of each scheme fails to accord with the built language and scale of the historic perimeter buildings around the site, and each scheme introduces a materiality to the site that is in stark contrast to the existing condition. Miss Adams' proof of evidence undertakes an assessment of each proposal in respect of the base, middle and top in accordance with the visual impact section of policy D9 of the London Plan. The assessment demonstrates each scheme is inappropriate for both its immediate, for example, the overbearing relationship of the tall buildings and the Georgian Terrace on St Thomas Street, and wider context. In relation to the design of the public realm for each proposal, the proposed public realm for the schemes, although different, will be constrained, narrow, limited in variety and predominantly overshadowed, and will be dominated by the scale of the tall building, while some elements of what's required to ensure public space of appropriate quality can be secured by condition, for example, choice of materials, planting and a considered layout. These are insufficient to mitigate against the fundamental lack of space and the problems associated with spaces which are too small, too shady, and which, due to the ratio of building height to open space, are subservient to the tall building and dominated by its presence. Each scheme would disrupt the Shard status as a landmark and would result in a tall building that would stand out, visually dissociated from the London Bridge cluster. The London Bridge cluster can be understood as an area distinct from the historic terrace and group of buildings along Western St Thomas Street that include the appeal site. Each scheme would undermine the spatial hierarchy of the local and wider context, the distinctive character and appearance of the conservation area, and the relationship between the conservation area and the London Bridge cluster. Although the height of the 2021 scheme is reduced, the increased bulk and solidity results in a similarly harmful impact on the townscape. So by way of conclusion on this point, the schemes do not deliver the high standards of design and architecture required by the development plan and would fail to positively contribute to the local character of the area, the townscape and the skyline. Both schemes are contrary to London Plan and Southwark Plan policies and the NPPF. As Mr Glasgow will explain, having regard to the range of policy conflicts identified by Miss Adams' evidence, the manner in which these conflicts are aligned to the detailed criteria in the tall building policies and the development plan, the sensitivity of the context and the impact of the schemes on intermediate views and longer distance borough and strategic views, very significant weight should be attributed to these matters in the planning balance. I'll then deal with the Section 106 agreements. And Madam, in light of the explanation we had earlier, I don't propose to read this out if that's convenient. So then servicing, the Council's transport planning team, along with TfL, have consistently raised concerns in respect to the servicing arrangements of the 2018 scheme, both at the pre-application stage and following submission of that application. Those concerns have not been resolved, and TfL's concerns are such they've chosen to participate in the inquiry. First principal matter of concern is the use of St Thomas Street by HGVs, vehicles servicing the Georgian Terrace and Keats House, refuse collection vehicles and motorcycles for loading and unloading, which will be incompatible with the expected increased pedestrian use of St Thomas Street, and TfL proposals associated with the Healthy Streets approach. The other principal cause for concern is the increased use of White Hart Yard by servicing vehicles, which will result in an increased risk of collision between vehicles, pedestrians and cyclists, both within the yard and where the yard meets Borough High Street. Servicing issues associated with the 2018 scheme result in a number of policy conflicts with both the Southwark and London Plan, and Mr Glasgow will explain this should be given moderate weight in the planning balance. Then public benefits. It's common ground that both schemes will deliver public benefits, although the nature, significance and extent of the public benefits are matters in dispute. You, Madam, and the Secretary of State will need to consider the extent and significance of the public benefits weighed against identified policy conflict and harm in both the heritage and overall planning balance exercises. Parties have agreed a number of public benefits to the appeal proposals which are set out in the Statement of Common Ground. Principal differences in terms of the identification of benefits flows from the Council's heritage and design and townscape likely reasons for refusal. Specifically, the appellant identifies the replacement of a mediocre 1980s building, which makes an inefficient use of the site with a highly sustainable and efficient new building of exceptional design quality as a public benefit. As will be evident from the Council's written evidence, that is not agreed. The appellant also identifies specific heritage impacts as public benefits of the scheme, namely the removal of the office building, which is said to detract from the character and appearance of the conservation area and setting of designated assets, restoration and improvement of the Georgian Terrace, reconstruction and improvement of Keats House, improvement of the setting of the adjacent listed buildings, including the old King's Head Yard public house. With the exception of the restoration and improvement of the Georgian Terrace, the majority of works in relation to which the Council supports, it does not accept the matters relied on by the appellant will constitute benefits. The removal of the 1980s office building and its replacement with a tall building proposed by either scheme would, as we've already explained, give rise to significant harm to the conservation area in the setting of a wide range of heritage assets. Relocation of the facade of Keats House, usually a method of last resort for heritage assets, would harm its physical integrity. The impact of the schemes on the old King's Head public house would also be harmful, resulting in less than substantial harm through the loss of the yard's historic sense of enclosure and the complementary architectural language of the building line along the north side. Finally, although not referred to by Mr Gardard in his evidence, Mr Alford draws attention to servicing as a public benefit of both schemes. As we've explained, the servicing arrangements in relation to the 2018 scheme will give rise to harm. 2021 scheme servicing arrangements are acceptable, but do not themselves bring any public benefit. Then the weight to the benefits and whether they outweigh any harm. First, economic benefits. Nature of the economic benefits that will be delivered by the schemes is broadly agreed. The evidence shows the weight to be attached to these benefits is not. In opening the Council's case, we don't propose to rehearse all of those differences, but simply highlight some of the more important areas of dispute. The economic benefit of the greatest scale is the delivery of a significant quantum of office floor space. This must be viewed and assessed in its proper context. As Mr. Glasgow will explain, the Council set a strategy through its recently adopted local plan for the delivery of economic growth over the planned period, and the targets for employment floor space can be comfortably achieved without the uplift in floor space that each scheme would provide. Having regard to this, it's appropriate to place moderate weight on this benefit in the planning balance. Then social and environmental benefits. The provision of new public realm at both ground level and in the elevated garden spaces is a public benefit. However, the weight to be attached to that benefit must reflect the size, quality and functions of those spaces. Whereas the elevated spaces have the potential to be more successful, in particular the 2021 scheme's garden, which will be located at the top of the building as compared to the internal 5th and 6th floor garden in the 2018 scheme, the shortcomings of the public realm in terms of their quality, size, function and impact on heritage assets justifies the application of limited weight to this benefit. Provision of an alternative access into and out of London Bridge Underground station is likely to help relieve congestion on the footway on the eastern side of Borough High Street and is a public benefit. Given that the principal beneficiaries of the new access are likely to be those employed within the development, and the new access will not be very legible or obvious for those approaching from the east of St Thomas Street, this intervention should attract moderate weight in the balance. Then the heritage balance. In this case, significant harm would be caused to a wide range of assets, including those of the highest importance, not just in the London context, but also UK and international context. Harm is less than substantial, but individually and collectively it is significant and must attract considerable weight, amplified in this case due to the importance of the assets affected and the extent of the harm that's been identified. The extent of the harm and the importance of the assets affected is also reflected in HE's objection and its participation, as well as written objections from a number of other bodies. Paragraph 202 of the framework identifies that less than substantial harm to identified heritage assets must be weighed against public benefits. Our case is that the benefits don't come close to outweighing the significant and widespread harmful impacts of the proposals. We acknowledge the differing forms of the two schemes means the nature and extent of the harms vary, but the failure of the public benefits to outweigh the harms nevertheless applies to both. In overall accordance with the plan, the appeal proposals are in conflict with a number of key policies, the London Plan and Southwark Plan. In light of the importance of those policies and the nature and extent of the conflict, both schemes in conflict with the development plan were considered as a whole. Finally, whether the benefits outweigh any other harm, the appeal must be determined in accordance with the plan unless material considerations indicate otherwise. Having regard to the harm they would cause to the arising from the heritage impacts, design quality, impacts on townscape character and the skyline, in addition to the harm identified in respect of servicing for the 2018 scheme, protection of amenity for both schemes, the relatively modest benefits that will be delivered by the schemes do not outweigh the identified harms. While the precise nature of the harms and benefits is different for the two schemes, they're not so different as to lead to a different conclusion in terms of the planning balance. And so, Madam, for the reasons I've summarised to that more fully in the written proofs, it will be our case the appeals should be dismissed and Planning Commission listed building consent refused. I'm conscious I went over my time estimate and I apologise for that, but I hope that it's helpful nevertheless.
Thank you very much. Okay. Ms. String, is it Miss or Mrs. or how do you want to be addressed?
I mean, I'm not fussy, technically Mrs. But,
Okay, all right, thank you.
Anything's fine.
Yeah,
I'll answer to anything. Thank you. The Historic Buildings and Monuments Commission for England.
Should we just, if we get them?
Oh, I'm sorry. Yes. I'm so keen.
Very keen.
Yeah.
I like it. Thank you.
Thank you. The Historic Buildings and Monuments Commission for England, known as Historic England, is a non-departmental body, public body, sponsored by the Department for Digital, Culture, Media and Sport. It's the government's statutory advisor on all matters relating to the historic environment. Its role is to champion and protect England's historic places, the places and buildings that define who we are and where we've come from as a nation. It manages the National Heritage List on behalf of DCMS, the only official and up-to-date register of all nationally protected buildings and places in England. Historic England provides expert advice to local planning authorities, developers, owners and communities to help ensure our historic environment is properly understood, enjoyed and cared for. I might start referring to Historic England as HE because I've realised I've used those words many times and it's quite a mouthful. HE must be consulted on certain planning and listed building consent applications which may affect the historic environment. It routinely provides advice letters to local planning authorities, setting out relevant considerations and often giving expert opinion on the likely impacts of a development proposal. Usually, Historic England's involvement in development proposals ends there. Research commissioned to inform the recent advice note for tall buildings revealed that between 2004 and 2017, HE only raised serious concerns in 7% of tall building cases. The organisation is selective in its approach and its use of resources. The step of raising strong objections and appearing at a public inquiry is not taken lightly and is reserved for the most serious cases. This is such a case. The two alternative proposals for a 37 or 26-storey tower on the new City Court site would cause irreversible harm to some of England's most cherished and important historic places. Both schemes were considered by HE not only at officer level, but were also subject to consideration by its London Advisory Committee, which is reserved for novel and contentious cases. HE's evidence to this inquiry has also been the subject of rigorous internal peer review by senior officers and represents the settled view of the organisation on these proposals. As I've already made clear, HE's expertise is in all matters related to heritage. Our witness for this public inquiry, Alistair Young, has worked for Historic England for 9 years, first as an assistant inspector and since 2016 as an inspector of historic buildings and areas. He does not purport to have qualifications or specific expertise in matters of design, townscape and visual impact or planning policy, although he does routinely engage with these issues where they overlap or intersect with heritage concerns. Given Historic England's statutory remit, the evidence presented to this inquiry will be focused on identifying what is of heritage interest and value about the historic places that will be affected by the proposals and describing the nature and degree of harm that would be caused. Evidence will be given on the policy implications so far as policies relating to heritage are concerned, but HE will not otherwise call evidence on matters of planning or design and townscape. For the same reasons, HE will not comment on the weight to be given to non-heritage public benefits claimed by the appellant and will not seek to undertake the planning balance. A proportionate approach has been taken to the evidence in terms of the heritage assets Historic England has chosen to focus on. Tall buildings are visible over a large area and so have the potential to affect how we experience and appreciate many historic places. Furthermore, HE is not routinely consulted on development proposals. The requirement to consult is triggered by development proposals affecting Grade 1 or 2 star listed buildings or their settings and applications for new buildings on sites of over 1,000 square metres in a conservation area, among other things. With these points in mind, and consistently with the approach taken in the formal advice letters provided to the local planning authority, Historic England has focused on the heritage assets which would either suffer the greatest harm or which are of the highest significance. These are Borough High Street Conservation Area, Guy's Hospital, Southwark Cathedral, the Tower of London and St Paul's Cathedral. There are just a few overarching issues that I'll raise before going through each of those assets in turn. And first is the importance of a clear understanding of significance. In reaching a decision as to the acceptability of a development proposal, it is essential to have a clear understanding of what is of heritage interest about the heritage assets which may be affected, and where relevant, what contribution is made by their settings. Aspects of a heritage asset setting can affect its heritage interest and value positively or negatively, or may be neutral. Change within the setting can similarly be positive, negative or neutral, depending on how the change affects what is of value about the asset and the ability to understand and appreciate that. The NPPF reflects the statutory duties in sections 66 and 72 of the Listed Buildings Act by focusing attention on whether a proposal causes harm to significance of a heritage asset. A clear understanding of significance is therefore critical to a robust and credible assessment of impact. Starting with a good understanding of significance should point the way to what kind of building might be acceptable on any given site. The appellant has not demonstrated a good understanding of the significance of the appeal site and the surrounding area, or of other heritage assets which would be affected through change in their settings. This ought to be clear from the very fact that buildings of the proposed height are being promoted in this sensitive location. The appellant's failure to properly understand significance has led to highly questionable conclusions as to impact, most strikingly the claim that either of the proposed tall buildings would have a positive effect on Borough High Street conservation area. I then move on to the relevance of existing tall buildings in the vicinity. HE is not opposed to tall buildings as a matter of principle. They are a feature of modern London and there is a place for them. Indeed, they can have positive impacts. However, they can and often do have profound and far-reaching effects on historic places. It is essential that they are located correctly. It is a fact that there are already tall buildings around London Bridge Station, which are on the edge of Borough High Street conservation area and within the settings of many listed buildings within it, including Guy's Hospital and Southwark Cathedral. The appellant regards these tall buildings as having become a prominent part of the character and appearance of the conservation area and of the setting of other heritage assets. This leads to the argument that the proposals for the new City Court site would not introduce any effects which are not already present, essentially that it would be in keeping with the character of the conservation area. It's suggested that adding one more large building to an existing group of large buildings could not lead to a high level of harm. HE considers that this approach again demonstrates the appellant's flawed approach to significance. The fact that tall buildings already exist in the vicinity does not mean that they have a positive impact, or that further such development will not cause harm. Heritage duties and policy are concerned with preserving and enhancing special historic and architectural interest. Existing tall buildings do not contribute anything to the special interest of any of the heritage assets at issue in this case. In most cases, they conflict with it. The good practice advice, note 3, reminds decision makers that where the significance of a heritage asset has been compromised in the past by unsympathetic development affecting its setting, to accord with NPPF policies, consideration still needs to be given to whether additional change will further detract from or can enhance the significance of the asset. HE's position is that existing tall building development has harmed the special interest of all the heritage assets it has chosen to focus on in this inquiry. It distracts from and competes with the architectural qualities of these highly important places. The appellant's proposals would introduce these negative effects into the heart of Borough High Street conservation area. They would create new harmful juxtapositions and relationships with Guy's Hospital, Southwark Cathedral, the Tower of London and St Paul's Cathedral. These harmful effects are in no way mitigated or reduced by the fact that the proposal could be portrayed as more of the same. I then turn to the relevance of quality of design. The appellant's case is that quality of design is a principal consideration in determining the effect of the schemes on heritage significance, and that if a new building is of a high standard of architecture, it is likely to add positively to views in which it appears. As already indicated, Historic England will not be critiquing the proposed designs in its evidence, but these statements and others like them raise an important matter of principle. Whilst high quality design is always expected and is critical where heritage assets will be affected, the quality of the design will not of itself produce a development that has a positive relationship with historic places. Another way of looking at the matter is to say that, however well the architects have done their job, design cannot be regarded as good if it causes unacceptable heritage harm. HE's guidance is that there will be locations where the existing qualities of place are so distinctive and the level of significance of heritage assets so great that tall buildings will be too harmful, regardless of the perceived quality of the proposal's design and architecture. The new City Court site is one such location. I'll then give a summary of our position on each of the key heritage assets that we will be focusing on, starting with the conservation area. Borough High Street Conservation Area has long been recognised as an area of special architectural and historic interest, having been designated in 1968. The High Street is the focus of the conservation area, and there are two critical elements of its character which would be seriously undermined by either of the proposed tall buildings. First, the consistent 3 to 4 storey scale of buildings, which new development is expected to conform to and remain within. And secondly, the distinctive urban grain, which has evolved from long, thin burgage plots, subsequently adapted for use by inns set in narrow yards and ways, and later repurposed for commercial activity. The narrow yards add to the visual interest of the High Street and are a reminder of its historic legacy. They create a sense of enclosure. New development should be in keeping with this morphological character. A Away from the High Street, the St Thomas Street sub-area is significant for the restrained quality and consistency of its Georgian and Regency architecture, giving it a conservative, established tone. Again, there is a consistent scale of approximately 4 stories. These aspects of the historic and architectural interest of the conservation area would be seriously harmed by the proposed tall buildings. Either tower would loom over and dominate Borough High Street and St Thomas Street, reducing the ability to appreciate the consistent architectural quality and character of the area. They would exacerbate the visual distraction which is currently provided by the Shard Place and Guy's Hospital Tower, and bring a harmful and radical juxtaposition of scale and character right into the heart of the conservation area. Additional harms of a similar nature would be caused to the listed buildings within the area, most notably the listed terrace which forms part of the appeal site and the listed former church at 9A St Thomas Street. Either proposal would also result in the loss of the narrow King's Head yard in favour of an open space, which is inconsistent with the existing morphology. Historic fabric which contributes positively to the conservation area would also be lost. This would be harmful to the area as well as the listed King's Head pub. Additional harm would be caused by the proposed relocation of Keats House to deliver servicing access for the proposed buildings, with the 2021 scheme being more harmful in this respect. The proposed tall buildings would be seriously damaging to the special architectural and historic interests of the conservation area, the character and appearance of which is supposed to be protected by the designation. There is little difference between the schemes in terms of the degree of harm they would cause. In both cases, it would be at the upper end of less than substantial harm. The appellant's conclusion that the proposals would have a positive effect on the conservation area will need to be carefully explored. Turning to Guy's Hospital, that is listed at Grade 2 star and derives a large part of its significance from its formal architectural composition, with a large forecourt leading into quiet courtyards in a sequence described in the conservation area appraisal as quite exceptional. From within the forecourt, the neoclassical architecture can be well appreciated, and the crowning pediments on each of the 3 building ranges provide focal points, which are deliberately aligned with the central statue of Sir Thomas Guy. Tall buildings in the vicinity have affected the ability to appreciate the architectural significance of the hospital, but important views of the original central and western ranges from the entrance gates and within the forecourt can still be seen against a clear sky. Either of the tall building proposals would cause serious harm to the architectural significance of the listed hospital complex through a combination of height, proximity and contrasting architectural style. The verified views contained in the appellant's TVBHIA show very clearly how either of the proposed towers would dominate and seriously undermine the architectural composition of the west wing. The full impact cannot be captured in these images, as the proposed buildings are too tall to fit in the frame, so the effect would be even more extreme than the images suggest. Similar intrusive effects would be experienced in the western quadrangle. The west wing houses the hospital chapel, which is a place for quiet reflection and contemplation. Light coming through the 3 stained glass windows, which are mentioned in the list description, makes an important contribution to the intangible qualities of the chapel. The appellant's evidence confirms a 43 or 46% loss of overall light levels inside the chapel, assessed using climate-based daylight modelling. Alternative methods of assessment predict major reductions in vertical sky component, and for the 2021 scheme, major adverse impacts on daylight distribution. However the effect is measured, it is clear that there will be an appreciable loss of light through the stained glass windows, which are an aspect of significance and were designed to be seen and best appreciated in sunlight. The appellant accepts some harm to the significance of Guy's Hospital, but significantly underestimates it. The proposal would undermine important elements of the special interest of the hospital, and the harm would be at the upper end of the range of less than substantial harm. It should be recalled that Guy's Hospital is a highly important element of sub-area 4 of the conservation area. Moving on to Southwark Cathedral, the cathedral is listed at Grade 1 and has been a religious landmark and focal point since medieval times. The large square tower with its Gothic finials was intended as a striking architectural and religious statement and a visual spectacle. Despite modern development within its setting, it remains prominent and can be seen against a clear sky in many views, including from London Bridge, Montague Close and within Millennium Courtyard. In these views, the silhouette of the imposing tower and in closer views the detail of its impressive architecture is seen unchallenged by visual distraction. It retains a landmark quality, notwithstanding that modern tall buildings, in particular Shard, are present in the wider area. Both proposed towers would cause harm to the significance of Southwark Cathedral by introducing visual distraction and competition. From London Bridge, the towers would terminate views and draw attention away from the cathedral by rising significantly above it, adding to and exacerbating the effect of existing tall buildings by London Bridge Station. The 2018 tower in particular would be highly conspicuous in views from Montague Close. The appellant acknowledges that the relationship between the cathedral tower and the 2018 proposal seen from Montague Close is not a positive one from a purely visual perspective, and some harm to significance is acknowledged. Again, Historic England will demonstrate that the appellant has underestimated the level of harm that will result. It would be at the upper end of the spectrum of less than substantial harm. The 2021 scheme is lower and therefore less assertive and challenging in views, although still visually distracting. It would cause less than substantial harm towards the middle of the range. The harm is to a Grade 1 listed building and so should be given very great weight. Again, it should be remembered that Southwark Cathedral is the key listed building in sub-area 3 of the conservation area. Moving on to the Tower of London, the World Heritage Site is of exceptional historic and architectural importance, both nationally and internationally. Within the tower complex are a variety of designated heritage assets, including several listed buildings, a conservation area and a scheduled monument. However, the focus of Historic England's evidence is on the effect of the proposals on the outstanding universal value of the World Heritage Site. The tall building proposals would have broadly the same type of impact on the other heritage assets, such that a separate assessment was not felt necessary. The 2018 scheme would be clearly visible above the roofline of the Queen's House in the inner ward, where it would exacerbate the visual distraction caused by the existing tall buildings. It would further undermine the sense of enclosure and separation felt in the inner ward and the protective function of the concentric defences. By appearing directly above the roofline, the tower in the 2018 scheme would affect the ability to appreciate the domestic scale architecture of the Queen's House, which is part of the surviving medieval remains. The tower would also be seen above the Waterloo block when seen from the Royal Mint, further undermining the physical dominance of the White Tower from this view. Although in 2003 it was decided that the Shard would cause no material harm to the setting of the Tower of London, much has changed since then. It's now accepted that the Shard did have an impact on the visual integrity of the World Heritage Site, and planning policies had to be strengthened to lessen the risk of inappropriate development with an adverse impact on the tower's visual integrity. It is now well understood that tall buildings in the London Bridge area may undermine the tower's outstanding universal value. In this context, the appellant's claim that the 2018 scheme would cause no harm is unsustainable. Harm would occur towards the lower end of the range of less than substantial harm, but this harm is to a heritage asset of the highest possible significance. Finally, St Paul's Cathedral. Sir Christopher Wren's architectural masterpiece was designed to be seen and appreciated over considerable distances. It is listed at Grade 1. It is iconic and remains a defining feature of London's built environment. Whilst the dome is the most recognisable feature, the architectural contrast and relationship between the dome and the West Towers is highly important. St Paul's has a very large setting which has been heavily influenced by modern development. Historic England's concern is with the impact of the proposed tall buildings on the significance St Paul's derives from its setting, as experienced from two protected views identified in the LVMF. From Kenwood Gazebo, each of the proposed towers would appear directly behind the northwestern tower of St Paul's and would add to the sense of mass behind the cathedral, as well as adding to the visual severance of the west towers from the dome. The 2018 scheme would break the horizon, which would further draw the eye away from St Paul's. Cumulative harm would be caused to the cathedral's significance through further reducing the ability to appreciate its distinctive silhouette and the contrasting elements of its architectural composition. The 2021 scheme would be less harmful due to its reduced height, and in fact it would not break the horizon. From Parliament Hill, there would be some additional cumulative harm arising from further visual distraction and a reduction in the prominence of St Paul's. Again, the 2021 would break the horizon in this view, which would make it more conspicuous. It's considered that the 2021 scheme would not cause any appreciable harm from this viewpoint. The proposed tall buildings would cause a low level of less than substantial harm. However, the harm is to one of the nation's most cherished and highly graded historic places. So I move on to the implications of that harm. And in terms of development plan policy, findings of harm to the significance of heritage assets are relevant to the application of several policies in the London Plan and Southwark Plan, most notably D9 and P17 on tall buildings and HC1, P19 and P20 on heritage. Historic England will not express a view on overall compliance with these or other policies in the development plan, but notes that the finding of harm which cannot be outweighed will inevitably lead to non-compliance with a range of relevant policies. And then moving on to statutory duties and the framework. The statutory duties in sections 66 and 72 are reflected in the framework, which confirms that when considering the impact of a development proposal on a heritage asset, great weight should be given to the asset's conservation. Conservation in this context meaning to sustain and, where appropriate, enhance significance, in other words, to avoid harm. The more important the asset, the greater the weight that should be given to its conservation. Any harm to or loss of the significance of a designated heritage asset should require clear and convincing justification. Loss of a building or element which makes a positive contribution to the significance of a conservation area should be treated either as substantial harm or less than substantial harm as appropriate, taking into account the relative significance of the element affected and its contribution to the significance of the conservation area as a whole. Where a development proposal will lead to less than substantial harm to the significance of a designated heritage asset, this harm should be weighed against public benefits. In this case, harm would be caused to several designated heritage assets, which includes some of the most important historic places in the country. The greatest possible weight should be given to this harm. The harm is primarily a consequence of the height of the proposed towers, which would make them visible over a wide area and create damaging juxtapositions of scale locally. Tall buildings have a place in modern-day London, but this is emphatically not the right place. Historic England does not express a view on the weight to be given to wider public benefits in the balance, but will demonstrate that the heritage-related benefits which are claimed are minimal and are dwarfed by the harm that would be caused. The heritage harms should lead to the refusal of planning permission unless there are other public benefits of sufficient weight to clearly and convincingly justify the serious harm. Thank you.
Thank you.
Coming round now, Mama. I won't start reading before it gets to everybody because I would have finished it before it arrives, as you say. Just give me one moment, please. Good. So just a few words by way of a brief opening. So a few words of introduction, first of all. The 1970s and 1980s were not kind to the part of St Thomas Street which comprises the appeal site. The Georgian Terrace was botched, the Victorian Villa, Keats House, was demolished with just its facade retained, and a ghastly licorice all sorts office block was attached to both. Fast forward 40 or 50 years, and the London Bridge area has undergone a remarkable transformation centred on the colossal Shard, just 2 minutes walk away from New City Court, and finds itself described in the Southwark Plan as, and I quote, a globally significant central London business district. Our layer of history, because let's face it, that's what it is seen in the growing cluster of tall buildings, including Shard Place and the News Building, which are even closer to New City Court than the Shard, which is the pinnacle of the cluster. Little wonder the Southwark Plan describes London Bridge as a focus for new tall building development, and within an area where we expect tall buildings, by which it means more of them. Nor that farther to the east, along St Thomas Street, new tall buildings have been consented at Capitol House, which is underway on site, Edge London Bridge, and Vinegar Yard, which has been approved by the Mayor of London. As is seen here in Southwark at London Bridge, and across the bridge in the city, tall buildings are found cheek by jowl with, and in the closer and wider settings of heritage buildings and areas. How could it be otherwise? The contrast in scale and style this brings are threads in a rich tapestry. They are the threads woven by us in our era. Isn't it ironic, I remember this well, that just a few years ago English Heritage was fought to stop the Shard being consented, and yet now we find the Southwark Plan protecting its prominence. But then again, isn't it often the way that what is controversial today is cherished tomorrow? Either of our proposals to replace New City Court, one with a 37-storey, the other with a 26-storey tall building, would sit well in the established and growing cluster. The taller and slimmer 2018 scheme at AOD plus 144 metres would be just a tad lower than the Guy's Hospital Tower and less than half the height of the Shard, while the less tall, wider 2021 scheme at 108 metres would be just a little taller than Shard Place and about a third of the height of the Shard. So why are we here? The Council consider the harm they and Historic England conclude each of the proposals would cause to designated heritage assets would not be outweighed by the public benefits of each scheme respectively. In addition, the Council consider both schemes poorly designed and harmful in various ways to townscape and local character. Plainly, to the extent that there is any such harm, it too would need to be weighed against the public benefits. Now, we disagree wholeheartedly. Beginning with heritage, there are all sorts of issues of approach which need to be ironed out, such as how does one work out what is less than substantial harm, and then what degree of less than substantial harm a proposal would cause. And in the case of each of the listed buildings referred to, why is it being said that either of our proposals appearing in their settings would lessen the heritage significance, the heritage interest of the asset itself? Similar points arise with regards to the Tower of London World Heritage Site across the river. And the site is within a conservation area, so too is Shard Place across the street from us. And as this is an area-based designation, why is it being said that either of our proposals would lessen the heritage significance of the conservation area? Starting with the Tower of London, whereas the Council consider there would be just below mid-level less than substantial harm, 2018, and low less than substantial harm, 2021, while Historic England concluded would be low and very low, we don't see any harm. After all, we're talking about the outstanding universal value of the World Heritage Site, and it's hard to see how a tall building and a cluster of tall buildings on the other side of the river from the tower would diminish the attributes that make the tower of such significance. The Council consider either proposal would cause towards upper less than substantial harm and Historic England high less than substantial harm to the heritage significance of the Borough High Street conservation area, whereas we see an overall enhancement, not least through opening up the site to public access for people to enjoy. Yes, in either case, there would be a tall building in the conservation area to join Shard Place just across the street, and the other tall buildings, not least the Shard, a few paces away from the conservation area. But as the conservation area appraisal says, and I quote, Borough High Street has throughout its history had to accommodate change, and part of its character is due to the immense variety that change has brought. Now that was written in 2006, since when there has been more change and greater variety added to the continuum. Similarly, the Council consider either proposal would cause harm towards the upper end of less than substantial and Historic England high less than substantial harm to the heritage significance of Guy's Hospital, whereas we say it would be considerably less than this. Guy's setting includes striking and prominent tall buildings. The point is not one of precedent, but rather that Guy's intrinsic heritage interest remains, even though in this century it finds itself in the midst of a globally significant and growing business district. The Council consider either proposal would cause harm towards the upper end of less than substantial to the heritage significance of Southwark Cathedral, while Historic England is a bit more nuanced, with high for one of the schemes and medium for the other. Our view is that in either case it would be considerably less. As the Conservation Area Appraisal says, the cathedral is set within the ever-changing environment of its modern setting, and that of course was written in 2006, a few years before the Shard added another layer of change. The council believed there would be less than substantial harm to several other heritage assets, including various in St Thomas Street, where we see no harm. Now, whoever you end up agreeing with, or whatever conclusions you reach steering your own course, you might disagree with all of us, applying the strictures of case law and planning policy, any harm would need to be weighed against the undoubted public benefits of either proposal. As for design, townscape and local character, suffice to say in opening that we consider each proposal to be of exemplary architectural and design quality. This part of Southwark is in safe hands with the highly renowned and exceptionally talented Simon Alford and his colleagues. The council's relentlessly negative analysis, well, it's a hatchet job really, tells us more about the lack of balance in the analysis than it does about the two schemes. The townscape hereabouts has undergone and continues to undergo huge transformation, in which taller buildings are an ever-increasing characteristic, bringing with them contrasts in scale and style, which is all part of the area becoming a globally significant business district in one of the few true world cities. To the extent that any harm would be caused, and it seems to us impact is probably a more apt term than harm, to coin a phrase, it would be the shock of another new rather than the new, as there would be nothing shockingly new about a tall building in an area earmarked for more tall buildings. The phenomenon is well known. New buildings are loved or loathed. If they're tall, the commendation or condemnation is all the greater, and feelings change over time. The Shard is a great example of this. Meanwhile, you will carry your conclusions forward into the overall balance that needs to be struck. I turn to the public benefits. Now, the public benefits either scheme would bring, cumulatively, are off the scales. All bar one of the benefits are agreed. The one that isn't is whether architectural and design quality should feature in the list. Where the council and we really differ is the weight given to each benefit in turn, and then to their accumulation overall. The council consider that overall the benefits amount to something, and I quote Mr. Glasgow, modest. The temptation to insert an exclamation mark here is hard to resist, whereas we consider them of very substantial weight. Either proposal would bring a major improvement in the amount and quality of office space on the site, and thus in the number of jobs and the contribution to the local and wider economy, affordable workspace, a significant boost to the vitality and viability of the town centre, extensive public realm, which would truly open up this closed site to use by the public, together with an elevated publicly accessible garden, accessibility benefits and heritage benefits, and I note in parenthesis that the heritage benefits should be given great weight in their own right. There is one other public benefit we'd like to single out in these opening remarks, and that is the proposed new entrance to the underground station that both schemes facilitate, which in either case would mean that rather than passengers doglegging within the station and joining the tight and congested pavement of Borough High Street and its corner with St Thomas Street, they would be able to walk straight out of the station into the welcoming public realm on the site. To the council, this is a middling public benefit, not much to write home about, if you will, whereas to us, it's an exceptional public benefit, truly noteworthy, if you will. It's not a bad sense check of the respective assessments to stop and think about this one in particular. It's all very well talking up the harm while talking down the benefits, but somewhere along the line we need to get a grip. Overall, it's our case that applying the strictures of case law and planning policies, the cumulative, extensive and very real public benefits either proposal would bring would comfortably outweigh whatever less than substantial harm to heritage you find either of them would cause, and the same would go for any other harm you conclude would arise. Accordingly, we will be asking you to recommend, in a few weeks' time, to the Secretary of State that both appeals should be allowed. And those are our brief opening submissions.
Thank you very much. Thank you, everyone. Okay, we shall now break for lunch, and then we'll come back for the roundtable session with Transport for London this afternoon. If we come back at 2 o'clock, just to make it a nice round number, I don't anticipate sitting much beyond 4 p.m. today. So if that helps with transport home.
Shipped out the way we yeah, but imagine TFL perhaps in here.
I'm easy, so if they want to, yeah, wherever's comfortable. It's a friendly session, so okay, all right. So we'll reconvene at 2 o'clock. Thank you. If I can just ask you to introduce yourselves, I'll take a note of who you are. If you can just confirm your qualifications, any details you want recording in the decision notice with the programme officer afterwards as well, just so I've got an accurate note of who you are and anything that you want in the reflecting in the decision. So I don't know who wants to start first. So, sure. Yeah.
I'm Russell Vaughan. I'm a director at Transport Planning Practice, and I'm still am the transport consultant for the 2018 and the 2021 scheme.
Thank you. Okay, and
hi, I'm Andrew Eiley from TfL Spatial Planning. I'm a principal planner. My role at TfL is to lead on behalf of TfL responses to planning applications, both referable to the mayor, which this one obviously was, and non-referable planning applications on the TfL road network.
thank you.
My name's John Birch. I'm Principal Network Sponsor at Transport for London, specifically for Southwark. My role is varied, but in relation to this application, it's to comment on the operation of the highway.
Thank you.
And I'm Michael Glasgow. I'm a Principal Planner in Atkins London Planning Team, and I'm acting as Expert Planning Witness for the Council.
Thank you. Okay. Okay, so I've read the representations from TfL, the bundle here. I've got the proofs obviously from the appellant and the commentary from London Borough of Southwark, I can't speak, from Southwark on this topic. A statement of common ground is obviously very late. I got it, I think, about 6 o'clock on Friday evening. So I'm not as prepared as I like to be for these events, roundtable sessions. Where are we with the statement of common ground? I know there was a flurry of activity when I walked in.
So I've just sat down with Andrew and we've run through a few minor alterations and again, points we agreed on. Then there was one further comment from ourselves, which Andrew's just agreed to. So that is currently with our team, and we will now do a track change version for submission so that you can see where it's changed from the Friday submission. But so, they're all quite minor.
So what I've got in front of me is the Friday version, and we can tend to sort of work off that. And if there are differences that I haven't seen yet,
then
you can explain
we'll agree
those.
To those. Yeah.
Yeah, brilliant. Okay, thank you. And I know the Section 106 agreement is being worked on, and there's TfL input into that. We may come on to some of that today, but obviously we've got the obligation session towards the end of the inquiry as well. Okay. So my understanding is the number of the difference is the 2018 scheme and the 2021 schemes largely agreed. And in respect of the 2018 scheme, TfL are happy with the access to London Bridge Underground Station subject to the 106, but the concerns regarding the London Road network, and there's a few strands to that, including loading bay, pedestrian access, visibility displays, and impact on future schemes by TfL. Is that a correct brief synopsis as far as you're concerned?
Yeah, I think I think that's right.
Okay.
Obviously, yeah, we could go into more detail if you like on exactly the issues on the TLRN.
Yes, well, we'll come to that. I'm just sort of making sure I've not completely missed the issues there. So, okay. Basically, I mean, this is just a chat with me, asking questions, putting them to you, so I can understand and go away with a firm grasp of what the differences between you are in coming to my recommendation. I think what would help is just to have a discussion and a description of what the scheme is, what it does and how it's evolved. And if I come to you, Mr. Vaughan, for that first, and then I'll draw you in. Okay, and if you want to interject or make any comments at any point, anyone, just let me know. Okay, I'm sort of playing tennis here with the views, but yeah.
Yeah, so if we start with the 2018 scheme, the 2018 scheme from a servicing point of view, which is obviously one of the key discrepancies we have with TfL. There are two methods for the site being serviced. Smaller vehicles, so that's anything 4.6 tonnes or below, which is a transit van, so that's a standard transit van sized vehicle or below, would be able to enter the site via White Hart Yard, would travel through White Hart Yard and into a dedicated goods vehicle lift, where it would go down into the basement and undertake its servicing. It would then exit via a different but adjacent lift coming back up to ground level on the junction of White Hart Yard and King's Head Yard, because the sort of White Hart Yard comes around the corner, and those vehicles would then exit using White Hart Yard. So all of the servicing vehicles by LGVs would enter and exit via White Hart Yard. King's Head Yard, which is currently used to access an 8-space car park associated with the existing property, would not be used by any of our delivery vehicles. So it could still be used by delivery vehicles, for instance, to the King's Head pub. It is a public highway, they can continue to use it, but our vehicles would be requested not to use King's Head Yard, which we would use as an enhanced pedestrian route. So in essence, that is how the LGVs would service the site. Because of the restrictions in vehicle sizes, the yards, as I'm sure you're aware if you've walked around them, are narrow and have narrow entrances, which would limit the size of vehicles that can physically get through into the yards. For that reason, any larger vehicles, so that's 8-metre lorries and 10-metre lorries and refuse vehicles of that sort of size, would be required to stop on St Thomas Street as per the existing situation. So at the moment there is a loading bay. Well, I say at the moment, when the 2018 scheme was proposed, there was a loading bay adjacent to the property. The loading bay is still there, but it is currently not in use because of the footway widening proposals that TfL have put in place due to COVID. So the proposal was that the existing loading bay be relocated further to the east towards Keats House, and it would be extended to 14 metres in length. And under the 2018 proposals, that lay-by service area would actually be equivalently onto the footway. So what we would do is we would extend the footway out to take up the existing highway or carriageway where there is taxi ranks and parked cars and a service bay at the moment, so that when the loading bay was not in use, it would be flush with and could be used as footway by the pedestrians. Goods from that loading bay, and that would only be vehicles from HGVs, they would be trolleyed across the footway and into the back of Keats House, where there would be a dedicated lift to take goods that are being trolleyed down into the basement, where they could again be conglomerated with the rest of the servicing, stored and transported to the rest of the building from that service area. Similarly, the bins would be stored in the basement and would be brought up to ground level using that goods lift, and would then be collected by a vehicle stopping in the lay-by, and the goods would be trolleyed, the bins, would be trolleyed across the footway to the rear of the vehicle for refuse collection. So would you like me to discuss the 2021 scheme now, or?
Let me just come to the aside, and then we'll do that. Is that a fair and accurate description in your view?
Yes, I think, yeah.
Anything to add, or?
Not at this stage.
Not at this stage. Okay, that's helpful. Okay. Right, 2021 scheme then, please.
The 2021 scheme proposes an at-grade service area to the rear of Keats House. So Keats House again would be moved to provide a vehicle crossover accessed from St Thomas Street. So the vehicles would be turning into the service area from St Thomas Street into I suppose I would describe it as an undercroft servicing area. So it's at ground level, but with buildings above it. Within that area, there are sufficient bays to accommodate the vehicles. And in addition, there is a turntable proposed so that the largest vehicle, for instance, the refuse vehicle, which is the only HGVs we are proposing in the 2021 scheme, can turn around within the basement, so they would enter and exit in a forward gear. And all deliveries would take place from within that at-grade service area. It's worth noting, while it's not a servicing point, but both schemes have two disabled parking bays within the service area. So in the 2018 scheme, they would be accessed using the vehicle lifts. In the 2021 scheme, they would be accessed from St Thomas Street.
Thank you. And just to confirm that accords with your understanding of the 2021 scheme?
No.
Okay. Okay. So one of the issues is future schemes by Transport for London. So could you just sort of explain to me just an overview of the activity around the area and what the Transport for London are wanting to do in the future, just so I can understand the baseline of that, please?
Okay, I'll give it a go, and John can chip in if I get it wrong. But it is quite complicated. But up until pre-pandemic, actually, there's a number of London Bridge has seen a number of changes. I think it's been alluded to earlier in the statements. A big change for us was the London Bridge station works, which had required St Thomas Street to be closed for a while. And when the works finished, it was about 2018, 2018, we consulted on what the future of St Thomas Street could look like. And when we got the consultation, it's an informed consultation, really. It wasn't really, this is what we want to do. It was, these are some of the options. What do you think? And after that exercise, we got a lot of feedback from public members, councillors, assembly members, I understand, all with various ideas and not liking what we proposed. So effectively, there was a longer term scheme that we wanted to put in cycle tracks to provide two-way cycling, because immediately after the works, the St Thomas Street was effectively like it is now. It's one way eastbound, one way westbound, which you can't cycle down. There's no contra cycle facility, so it's we don't really like having roads that are just one way for traffic and cyclists. It increases severance for cyclists. So that was the idea behind the longer term scheme. And for various reasons, principally COVID, work on that was stopped in about 2019. So we got to the stage of had some draft plans that we never got to share it, never got to publicise, but we did share them in informally with developers like GP and the Beckett House developers and the Vinegar Yard people, just so they could see roughly what we were planning to do on St Thomas Street. But then COVID priorities went elsewhere. We also had resource problems. As you probably know, the government and TfL are having a debate about how to fund TfL going forward. So that's all kind of it withered. And what we've got now is what will be there for foreseeable future. A further change was the COVID situation. So as you've probably been out on site and you've seen some blue barriers there, that was there was a London street space plan that the mayor published during COVID to provide more social distancing. So those blue barriers are a direct result of that plan. Put on under, I believe, emergency measures.
Yeah, so they were emergency measures that were introduced using special powers introduced by the government, which limited the amount of consultation. So the measures which are in there at the moment are temporary, they're barriers, and you may have seen they're being knocked over, causing safety problems. So the idea is that we would have a semi-permanent scheme that would look to put in some more sturdy materials rather than having the barriers, and putting a temporary footway there. At the very least, till the end of the pandemic, and social distancing isn't required as much. But in the longer term, I think because of the results of the consultation that Andrew referred to, I think we were criticised for not being ambitious enough. So I think once we're post-pandemic, the idea is that we would go back and look at some of these more ambitious designs that we've already started design work on, and potentially implement those.
And then I think whatever the direction of traffic flow, etc. I mean, we do have to be very wary of the servicing arrangements for the Shard, because that's the only service that's for the Shard, for London Bridge Station as well. But the gist of it is there's no two-way cycling down St Thomas Street, and that would be, I think, the ultimate goal, to get two-way cycling somehow in St Thomas Street. We've already heard anecdotally Southwark have been talking to us about they're worried about people cycling up the road the wrong way, and obviously the safety risk. So there's a fair degree of pressure to do something there. But yeah, it's too early to say what that will be. Yeah, I think that's probably is that.
Can I just add to that? I think the concern as well is, in terms of any future scheme, how that interacts with an increase in servicing from the highway, and the problems that causes, and whether it's actually feasible. I think the concerns from our perspective are, if, for example, a loading bay that's being used on street isn't accessible, where does that service vehicle go? And how does that tie in with our new scheme? And I think that's the problem that we have, is actually servicing from the highway rather than servicing from off street.
Thank you. Did you want to make any comments on what we've just heard? Or?
No, I generally agree with what Andrew's saying. I think the only points I would make, just for clarification when you're looking at the schemes, is that when we prepared the 2018 scheme, that was under a proposal from TfL for the traffic to be travelling westbound, so into London. So that was the scheme we were working under at that point. Whereas when we got to the 2021 scheme, as you said, the schemes have evolved, further consultation had taken place. I think one of the key issues was this contraflow cycle lane, and that's why TfL have looked at the option of flipping the road the other way. And so that's why, certainly for the 2021 scheme, we looked at, in fact, accommodating any options, so coming in from the left, the right, you know, all directions, etc. But obviously when the 2018 scheme was undertaken, the only proposal on the table at that time was a westbound. And then following that, there was a period where I think the end of the road was shut off to HGVs, because there was an issue with HGVs coming in, turning up at the Shard and reversing back round and exiting. But again, they were looked at in relation to all of those, and we also did a series of routing drawings with Southwark to ensure that the vehicles would be coming in from the agreed directions to meet whatever TfL proposed for St Thomas Street.
And that would be included in the travel?
Within the servicing management plan, for instance, there's a lot of drawings showing the key routes, because it's that balance between taking a direct route to the site but trying to stay on the strategic highway network for those servicing vehicles.
Thank you. Just before we drill down to the nitty-gritty, I'd just like to get an idea of sort of the wider characteristics of the area. So we're going to be hearing a lot about the conservation area and its attributes and the yards, etc. And then obviously there's the issues of servicing, deliveries, goods, etc. So could just have a an understanding of from all sides of the sort of issues and the servicing arrangements that are in place around the area and what sort of happens at the minute in general.
Oh, yeah. London Bridge is a very interesting area, isn't it? It's with Borough Market there, we've got a lot of commuters, we've got a lot of tourists, we've got a lot of visitors. It's a very historic area. It's an area of change. I think it's been emphasised earlier. Borough High Street in particular is certainly in my patch. I deal with kind of southeast London and south of Borough, and it's one of the more interesting TfL roads because it's the character is very different to a lot of TfL roads. I think I've dealt with planning applications for every other building down Borough High Street. They're all on street loading, and it's just a very historical area, and there's not much road space. Borough High Street's incredibly mixed route. There's I'd say a higher than very high level of pedestrian activity at all times of day and night, particularly around the site, around the underground station entrance because of Borough Market. So it's not just the AM, PM weekday peaks, it's evening peaks, it's lunchtime peaks, it's weekend peaks. And obviously a lot of people come out of Borough High Street tube entrance to get there. So the nighttime economy is really strong, one of the strongest in London in this SE1. Borough High Street as well is also an increasing number of cyclists are going up there. It's not actually a side and cycle route, but it is a key route into the city from Elephant Castle. And we see more and more cyclists go up and down there as well because we've recently closed London Bridge to vehicles, which has made a huge difference to the feel of cycling across London Bridge. And certainly on my route to work, I used to cycle off Southwark Bridge, but now I cycle over London Bridge because it's that much quieter. There's just buses and taxis. There's no vehicles on there at the moment. And I think we've seen, I don't know anecdotally, I don't know if John's got any facts and figures, but certainly we've seen an increase in cycling up and down Borough High Street corridor, and the road's very narrow, and we've got on-street servicing, we've got a busy bus corridor, it's a busy cycle corridor, busy pedestrian corridor. That obviously creates challenges for managing the network safely, smoothly. Cycling up, particularly outside that bit of the upper end of Borough High Street, is quite hairy. And I know we're talking about St Thomas Street loading bay, but I think we mustn't forget the fact that White Hart Yard is also a key part of the servicing of the 2018 scheme, and vehicles coming in and out of those yards is quite hairy for pedestrians and cyclists because the sight lines are just so short. St Thomas Street itself is very busy crossing because London Bridge, the main London Bridge station entrance, is on the other side of Guy's Hospital entrance, and that crossing there is very, very busy, and people filter out along St Thomas Street, particularly past Keats House, down towards Borough High Street, and obviously with a big new office block there's going to be more pedestrian activity there, more movement across St Thomas Street, along St Thomas Street. So generally, it is a very busy area. Yeah, it's very few lot of peaks. Typical even in London, but even more so, I think, here, because it's very concentrated, and it's with all the St Thomas Street cluster. You can see on the plan there, obviously, the numbers is going to go up and up. So yeah, and it's our job to manage the network safely and efficiently.
But I just add that it's important to differentiate between the sort of disparate characteristics of the Transport for London road network as well. So Borough High Street is heavily trafficked with motor traffic, but St Thomas Street is slightly different, and I think that's historical. Once upon a time, it was used for more traffic, but now, as we've seen, particularly during the pandemic, it doesn't need to carry that much traffic. So the question is, do we design the road to cater for motor traffic, or do we cater for the more dominant traffic, which is pedestrians and cycles, and try and change the characteristic of the street in terms of our Healthy Streets agenda?
If we just go to the council, is that your understanding of the sort of general characteristics of the area?
Yeah, I think
Anything to add?
Andrew's presented a fair summary of our understanding of London Bridge. I mean, the area vision in the Southwark plan points to London Bridge as being one of the UK's fastest growing transport hubs. And I think that's partly a reflection of the redevelopment of London Bridge Station and the works that are associated with that. But obviously, as Andrew and John just explained, that has a corresponding impact on the level of pedestrian activity and cyclist activity in the area. And in addition, because of the range of destinations, the mix of land uses, there isn't the natural AM and PM peak that you might experience elsewhere. There's heavy usage in the lunch times and in many cases at all times of the day. I think just in terms of the sort of baseline conditions, which is one of the questions you asked originally, the transport assessment is actually quite informative in setting out the nature of activity in the area, specifically on the east side of Borough High Street, which we've just been discussing. The pedestrian flows in the morning, lunchtime and evening peak can be in the region of 2,500 to 3,000 people, and it is one of the busiest stretches of footway in the local area. Similar with cyclists, that can routinely reach around 1,000 cycle movements in the AM and PM peaks. So we shouldn't sort of underestimate the nature of activity in the area. And then just on servicing, which is perhaps an area that I have a little more insight to, having lots of different schemes in the area. I think it's a common principle for most of the major developments along St Thomas Street that we've pointed to in the statements of common ground for planning issues and in my proof, that servicing is undertaken away from St Thomas Street. So Shard Place, which pretty much sits opposite the application site, has a fully internalised servicing area. And similarly for the St Thomas Street schemes, which you can see on the model in front of you, a defining principle of those developments has been that all servicing activity is taken off St Thomas Street. And that's a reflection of the baseline condition that Andrew and John have described, but also the way in which we see the area changing through the station and the associated developments.
Thank you. Did you have any comments?
The only point I was just going to respond with regards to the servicing is I worked on Capitol House, which is the 1,000 student accommodation tower, the other side of the Shard, which with our consultations we had with with Southwark, we removed the loading bay so that all servicing was taking place from street and was not taking place from St Thomas. It takes place off of Melia and the adjacent road, sort of the side roads, essentially, without any loading bay for that building.
Okay, that's helpful in just terms of scene setting. So if we work through the differences and the areas of disagreement between you then. I think if we start then with the loading bay, obviously the design's been borne out by yourselves. If you just want to describe how that came to be, and then we'll go into the actual issues between you with it. Okay.
Yeah, fine. So same point for the 2018 scheme. It's worth noting that when the proposals were originally submitted, this was prior to any consolidation. So at that point, there was expected to be a higher number of vehicles using it. Then following further discussions, we refined it and consolidated our deliveries. But from the point of view of the actual loading bay, I say there is already an on-street loading bay on St Thomas Street, which serves our development and the pub at the western end. and the proposals were to relocate that down towards Keats House so that it would be essentially directly opposite the access route to the goods lift. So in order to minimise goods being trolleyed across the footway, they would be able to stop and just go straight across the footway and into the building to have those goods delivered. That loading bay is 14 metres long. Now, what that means is that it can accommodate one 10-metre rigid vehicle, so that's one 10-metre lorry, or a 10, 11-metre refuse vehicle, for instance, with space behind to get the bins in and out. But it also meant that I won't say more common, but when you're driving a vehicle, old people like me with our old driving licences were allowed to drive an 8-metre lorry without having an HGV licence. So that means there's an additional benefit in people doing deliveries in 8-metre rigids. And that 14-metre bay did allow for a transit van or somebody else's vehicle, for instance, a car stopped there or something like that, and you could still get an 8-metre lorry into the bay. So it would accommodate, shall we say, 2 smaller sized servicing vehicles or one 10-metre plus vehicle. Obviously, the requirement for that loading bay was born from the fact that the design for the 2018 scheme meant that the servicing was split between the yards for the smaller vehicles and the on-street servicing for the larger vehicles. So that was the design process we went through, and that's the rationale behind why we believe that was and continues to be acceptable. We then had further discussions with TfL and Southwark, who highlighted their issues in relation to that on-street servicing arrangement. So on that basis, given that there were two things we looked at, one was following a response from TfL where TfL set out a number of potential options to redesign the scheme in order to put a ground floor service area in the scheme. So we went away and over a number of months with the architects, we worked through essentially the 2 options that TfL had suggested, and we went through all of the pros and cons of those and how they would work and the impact they would have on the scheme and on the public realm and the other issues. So we looked at those and we came to the conclusion that an on-street servicing bay an on-site servicing bay associated with the 2018 scheme was not the right solution. This was also confirmed when we discussed it with GLA. They also agreed that was not the preferred solution. The other element of work that we did, which allowed that decision to be formulated, was we did some extensive work in relation to consolidation of deliveries. So previously on St Thomas Street, we were looking at around about sort of 22 HGVs and 2 refuse vehicles a day just associated with our site turning up. And obviously, from a road use point of view, some of the arguments that TfL were making about, for instance, the accessibility of the bay, the crossing of the footway, etc., were valued with that number of vehicles. Following the consolidation, we managed to get that down to 5 HGVs and 2 refuse vehicles a day, which is in fact slightly lower than the existing number of vehicles that are servicing the site from the existing loading bay. We also agreed as part of the consolidation process that we would manage the hours of deliveries. Now, clearly, hours of deliveries were already managed to a degree because that loading bay, being on a red route, was restricted to only being between 10 and 4 in any case. But we would look at restricting them so there would be no deliveries in the AM peak, the PM peak, or the lunchtime peak. So we took the 2 hours out in the middle of the day for lunchtime as well. So what that resulted in, as I've set out within my proof, is that during the working day, there are actually less vehicles and they're avoiding the key peak periods. So on that basis, we still believe that that on-street servicing solution is valid and workable.
Thank you. Any comments on that?
I think on the wider planning issues that Russell mentioned, I've had it, and how the GLA came to the conclusion in the stage one report that it was on balance okay. I think it's a bit unfair to say that TfL agree with that. I think that it was obviously when we work the GLA on referral plan applications, there are often cases where transport issues that TfL don't agree with, but the GLA, their decision, or they advise the mayor, but ultimately the mayor's the decision maker. So I think if we did it, because I wasn't involved at the time, I know a colleague was, and I remember talking to him about it, and I think it'd be fair to say we reluctantly agreed that on-street servicing on St Thomas Street was on balance acceptable because all the other heritage issues, etc., that the GLA thought outweighed this issue. And I think crucially, we were very surprised when a year later there was a scheme that came in with with servicing that we'd asked for. I think that's what surprised us, because we, as Russell said, a very long negotiation. I've seen emails that over months about the on-street servicing. And yes, the conclusion of the GLA stage one report is on balance. We accept this. But then the 2021 scheme comes in with an off-street servicing arrangement, which is apparently exactly what my predecessor asked for. So we're kind of thinking, why is this? How can it work in one scheme but not another scheme? So that's kind of a fundamental issue, I think, where we're coming from. Because I think in London Plan Policy T7, it actually, as you're no doubt aware, it says, let's read it now.
So what policy is it?
So London Plan Policy T7.
T7, thank you.
Bear with me, I find it. T7. So this is delivery, servicing, construction. And H. Yes, so sorry, G. T7G. So development proposals should facilitate safe, clean and efficient deliveries and servicing. Provision of adequate space for servicing, storage and delivery should be made off-street, with on-street loading bays only used where this is not possible. And so at the time, you could, in 2018, with the work that Russell did and the work talking to the GLA, the decision was made that it's not possible to do off-street loading. So therefore, G policy T7G looks like it's been met. Yeah, but then I say 2021 scheme comes in and it has off-street servicing. But that kind of threw us a bit.
Because one of my roles is, obviously, I've got to deal with each scheme on its own merits. And it's not the case that the second scheme chopped 10 stories off and it's fundamentally similar. It's quite a different design ethos and concept, and we'll hear more about it over the course of the inquiry. In terms of the 2018 scheme, setting aside the 2021 scheme, and I fully understand and appreciate that's TfL's preference, do you consider this scheme to be the best it can be, or do you think there are other measures that could be included.
I'll just go through some of the issues with the loading bay.
Okay.
Or any load, yeah, particularly here, but a loading bay. First of all, it's subtly changed since the 2018 scheme was determined. Or stage one was that we've now got the footway widening scheme for COVID, and that's going in permanently, as John mentioned. So we will have a nice wide footway all the way down to Thomas Street from approximately Keats House to High Street, which is really good because it gives more space for pedestrians, and in line with healthy streets, everything we're trying to do is to give pedestrians space to move, to etc. And obviously, we did have, as Russell said, we had a loading bay in there prior to the widening scheme. And so putting in a loading bay would mean taking out 14 metres of our new widened footway. And you could argue, is that a retrograde step when we're meant to be delivering healthy streets and prioritising pedestrians? So that's one issue. The second issue, kind of related to that, is the trolling of the goods across the footway. And it does happen elsewhere in London. You can just go outside here and there are people be doing it. But the fact that this is a new development seems, a big new development, as you can see by the model, as kind of having goods for such a big development trolling across the footway seems a bit retrograde. And of course, we're looking at healthy street. You've got 10 healthy streets indicators and things like we're meant to be having streets that people feel relaxed. If you're walking past there and someone's got a big trolley and tells you to stop, is that relaxing? It's pedestrians of all walks of life. You could have kids walking along there. You could have some sort of party sighted. So it doesn't sit very well with the healthy streets indicators. Not too noisy. Trolleys running across. People safe. These are just the 10 healthy streets indicators I'm just picking out. It's just a fact that trolling goods across footways don't really help some of those healthy streets indicators. Future proofing as well, that we talked about earlier, that having some sort of cycle track in there, obviously we would need a cycle track with at least one direction. Ideally, we have bi-directional cycle tracks, as it's the standard gold standard. Putting in a loading bay where DP or the applicant wants it would make it less road space to put in what we want in the future, or what stakeholders want. Just the fact that we have to walk around loading bay.
Can I just interrupt? Because obviously there was a loading bay serving the appeal property. That's out of action because of the temporary widening. What's done there now in terms of servicing the existing building?
I can probably answer that. The simple answer, we don't know, but certainly when you look on Google Earth and things, you can see there's a lot of vans that are stopping in the parking bays on the northern side of the road, and there's a few strategically moved barriers that would allow somebody to cross the road and get through the barriers to the buildings. In fact, I think there's an official gap in the barrier opposite sort of Keats House, so vehicles stop on the northern side and just cross the road and then cross. So at the moment they're trolleying across the road and the footway, I assume. I don't know that for sure, but that certainly seems to be the only available option and is borne out by what you can see on Google Street View.
Thank you.
Can I just add to what Andrew was saying? Even in TfL's own design standards, we state that if there are alternatives possible, then those should be looked at. So the question is, does servicing have to be undertaken from the highway, or can an off-street service be provided? So that's one of the important things to consider. So we're not saying that, I mean, it would be foolhardy for us to say that no loading takes place from the TLRM, because we know it does. It's just, do we want to create more, and the conflict that creates with other road users? And additionally, if any future scheme does provide the cycle lane and widened footway, what that means is that the main running lane of the carriageway will be so narrow that if anybody stops there, it will be obstructing the highway. So as I said earlier, if a vehicle isn't able to access this loading bay, which for a lot of the time that might be the case, but we don't know exactly because we can't predict the future, obviously. But if that bay is occupied by another vehicle, where will the service vehicles go without obstructing the highway or being in contravention of a red route restriction? And just to add further to that, this is a problem that we do see both on our network, on the borough network, where developments are approved on the basis that certain loading bays will be used, but then those vehicles aren't always able to use them. And that's actually stated in our curbside loading guidance as well, that problem. And issuing fines to people contravening those restrictions doesn't really have much benefit. And again, the curbside loading guidance that we produced acknowledges that businesses simply increase the cost of deliveries to take into account the fines that they receive. So ultimately, it's a lot easier for many service vehicles to simply turn up and load and unload wherever they want, and risk receiving a fine rather than adjust the logistics in terms of when they actually provide that service for when a bay is actually available.
And just on that point as well, it makes it very difficult to monitor as well, because Russell talked about consolidation, which is good stuff. It's pretty standard stuff around London Bridge, because the Beckett House and Vinegar Yard have signed up to consolidations. Pretty much every developer now has to have consolidation as part of London, because this is literally just so many vehicles, the risk of having so many service vehicles in very small streets. So it's how that be monitored with an on-street loading bay is a question probably for Russell. And as John said, we can't dedicate loading bays to a single developer, so anybody can go there. How do we know the vehicles there are associated with New City Court and not with other businesses? What happens? It would have to be a degree of voluntary monitoring and enforcement, because our traffic wardens, I'm not sure the new name for traffic wardens is, but you know what I mean. They wouldn't know that a certain vehicle servicing New City Court during the lunch hour, when it was in the planning permission, it was only, or in the section 106, it wasn't allowed to be serviced between say 12 and 2. Certainly our traffic warden wouldn't know that, so there would be no penalty. So we rely on the developer, the applicant, to monitor that for us or something. I'm not quite sure how you can do that. And I think it's the trouble with on-street loading. It's uncertain that when you've got an off-street loading area, you've got certainty that the gates will be shut during the hours that we've all signed up to. That there's going to be capacity there. With the management regime, things can be monitored easily, because you can have either someone logging in, logging out, CCTV, etc. Whereas obviously on-street loading bay, you can't do that. It's much more, it's there for the public. It's not there for a single development, particularly not for development that's as tall as this one.
But in terms of, obviously, the 106 agreement would have a management plan in that, which I presume would look at monitoring, but I've not fully looked at the section 106 agreement yet, so I'm not fully familiar with that. Would that give you any comfort or assurances that there could be enforcement action, not necessarily in traffic warden fines, but in a planning context?
Well, yes, there will be enforcement. There will be a degree of enforcement highways, because obviously if they're there, if the service vehicle's there before outside of the allowable hours of the box. In terms of the other monitoring, the Southwark have I think it's a servicing bond. So if the numbers are breached, then the developer pays a certain amount of money for other cycling, walking, safety things around the site. We're still agreeing exact wording on that, but that sort of enforcement, yeah, it's not obviously not as well, as John said, though, deliveries tend to go where they want to go and what the best way of doing it, the most efficient way of doing it, even though that doesn't necessarily mean that they're doing the right thing. One thing I was worried about here is that in the worst case, that if the loading bays full, there could be temptation to the parking bays. If the parking bays are still there with the cycle tracks, just for instance, they could mount the curb. That would mean bollards, which are never very good because they more obstacles for pedestrians. Obviously, we could catch them with our enforcement officers, but they've got to be caught in the act. That's where I can just see that could be a case where we found as much as the people moving the barriers, the service, the pub down the road, they reverse. We've got pictures of them reversing in between the barrier and the footway. So again, this is all a risk. It's greatly reduced when you're off street servicing.
Yeah.
We've seen people park service in segregated cycle tracks. They just drive in, stop in a segregated cycle track, do what they need to do, drive. It's just, like the path of least resistance, I think, like water. It's and in terms of the numbers, obviously reducing the numbers means the risk is less, but there's still a risk. It's when is that risk unacceptable? It's very difficult to quantify.
So I'm not picking on you. I've got other questions, but just while we're with you, so obviously there's impact on future schemes. If this scheme weren't to come forward, so if I recommended it wouldn't be dismissed and the Secretary of State agreed with that, there's the future scheme that TfL are looking at, but there is an existing loading bay, and that presumably would need to be looked at and brought in somehow. And is there any difference between that and the 2018 scheme? Although the bay's bigger, but would you have to address it regardless?
Well, in a future scheme, we've looked at providing a loading bay because we have to take into account other businesses there. But I think that the real issue is about the interactions between the service vehicles and the service people using those vehicles and other road users along St Thomas Street.
But you would need to sort of look at it in the round in the future.
Yeah, but it would be a weakness of the scheme because to be able to do it, we would have to narrow the footway down to what we have at the moment. So part of the proposal was to widen the footway on the, get my bearings, the southern side, and provide contraflow cycling. Now, whether the contraflow cycle lane's on the north side or south side, we don't know yet. But previously in the proposals, they were on the south side. And again, it's that interaction between different road users. And again, I reiterate what I said before, is if there's an alternative, then that is a preference.
Okay.
We have loading bays and cycle tracks elsewhere for existing businesses. It's not ideal. I must have, as a cyclist, you're not quite sure what's happening. You see a van there, the doors are open, depending on which way the van's turned. It is quite. You do have to slow down and think: is someone going to step out or somewhere? And you often do. I mean, down Whitechapel High Street, down CS2, I think it is, on a regular cycle route. You have to be very, very wary of. Because people are not looking; they just unload, walk across the cycle track. So again, it's a risk factor that wouldn't be there if there was no loading bay there. It would be a safer design inherently.
Okay, and then to the council then, and we've talked about monitoring and enforcement. In terms of the management plan, have you got any comments on that? Do you share the concerns of TfL in that regard?
Yeah, I think so. I mean, the revised delivery service and waste management plan that will be secured through Section 106 has really got quite a lot to do, I think, in terms of mitigation. I mean, just going back to the point that Mr. Vaughan raised around numbers, I think even in the approach, which includes consolidation, there's still going to be an increase in intensification of the use of the bay on St Thomas Street. Just looking through the numbers in the submitted documents, I think the survey that the appellant team conducted suggested there were 9 two-way servicing trips with the existing building on a daily basis. And then in the scenario with the development going ahead, with consolidation, that's still an increase up to 15 a day, so 30 vehicle movements. I think the points that Mr. Hiley and Mr. Birch raised around the lack of control and the fact that existing businesses have to make use of it on street bay because they don't have an alternative means there are sort of cumulative impacts that need to be considered.
Sorry to interrupt, but as you've understandably moved into the Section 106 documentation, there are some quite important points we'd like to make about that, and I just wonder whether if there is an appropriate moment in your agenda for
can we
those
come
points
back to those sort of towards the end of the discussion, if that's okay? Yeah, I know we're touching on all sorts of issues, but
some of it's quite. But there's things that we'd like to say in response to what's just been said, particularly by Mr. Glasgow.
Okay.
I do just have one more point on the sort of the future strategy and mitigation, and that's just that through my sort of review of the material and conversations with Transport for London, as I understand it, there's a significant issue with the access into White Hart Yard as well, and that's a point that we haven't discussed at the same level of detail just yet.
No, I was going to come back to that as a separate. I'm just dealing with the St Thomas Street and the loading bay bit at the moment. That's
fine.
Okay. So we've heard lots there. Lots of risks. Busy area. We've got 2 schemes. One that was said, this is the best we can do, consolidating, and then a couple of years later, we've got a scheme that completely sorts all the servicing issues out. I appreciate it's a redesign, but is the 28 scheme the best one it can possibly be? And why is there such a big difference, I guess, between the two, dealing with each on their own merits? That's about 4 questions wrapped into one there.
I mean, clearly a lot of those points and arguments will come back to architecture rather than transport planning. But yes, in my opinion, the 2018 scheme that we ended up with the consolidated deliveries, the service bay and the servicing through the yards is and was the best solution for that site with that design. And that design offered many different benefits to the 2021 scheme. It had a taller, thinner tower, it had more open public realm, it had a different style of active frontages, etc., things like that. It had a smaller gap on the front end, and all of those points when we were looking at an option for how to accommodate a ground floor servicing area on the 2018 scheme. By the time you bought a vehicle in and spun it around, and one of the issues is that you need a large area to turn a vehicle around. Even with a turntable, it's a lot of space between columns. In order to be able to spin a 10-metre lorry, you need a 12-metre clear diameter circle, so there's a lot of space which would impact on where it would have been located. It would impact on the side of that tower, because fundamentally those columns came down in a location that didn't work there. And in addition, there was all the public realm improvements and the permeability through the site that got lost because routes that were going through the site became closed off because essentially that back area became a service yard. So there was, and visibility, actually wayfinding through the site became much more difficult because you ended up, from recollection, with, as you came out of the station, you turned the corner and then you were just met with a blank wall, which was essentially the back edge of the service area because of where it had to be located to be accessed from St Thomas Street. So yes, I'm still of the opinion that from a transport perspective, with the scheme that we had for 2018, that solution was the best and most viable solution for servicing the development.
Do you accept, some of the risks that have been identified?
So with regards to some of the risks, for instance, I mean, clearly one of the points that's being raised is, for instance, this temporary footway widening that's gone on at the moment, and we totally understand why TfL did it. We don't disagree that it was under those circumstances a good idea, but for that to become a permanent footway widening scheme, it would have to be consulted on. They can't just say, oh well, we did it temporarily and now it's going to become permanent. It would still need to be consulted on, and as you yourself have highlighted, they would need to consult stakeholders such as ourselves, and there is already an existing loading bay there. One of the other points that I think needs to be clarified is our end of St Thomas Street is actually relatively wide. The carriageway, when you walk down it at the moment, is wide enough to allow for parked vehicles, two-way lanes, so 2 lanes of traffic, one each way, and then more parked vehicles. You've actually got the equivalent of 4 lanes running through that section adjacent to our site. So to be able to fit in the loading bay, if you said the loading bay took 1 lane and the cycle lane took another, that would still leave 2 lanes of space for vehicles to drive through. So whilst TfL might be making a perfectly reasonable decision to narrow that carriageway down, because that's what they want to achieve for the Healthy Streets objective, it's not a physical constraint that is stopping them from doing that. In addition, the loading bay that we are proposing would be flush with the footway. Now, again, I understand that with any scheme and design, there are compromises, and one of those would be a requirement for some bollards in order to ensure that the vehicles stayed within those, the prescribed area. But it is undertaken across London where you put these loading bays in. There's some, for instance, on Oxford Street, one of the busiest streets in London. And there are these small bays that vehicles bump up, park in these small bays, and they unload. And specifically, because of the consolidation, we are endeavouring to make as many of our vehicles as possible take place overnight, so that, though there isn't that conflict, I think I have a slight, discrepancy or difference of opinion in relation to the numbers of vehicles. And I would refer to figure 2.3 of my proof, where we've actually set out the number and timings of deliveries currently taking place to our scheme. It's page 7, if that helps you find it. So yes, it's and that shows the existing number of deliveries to our scheme, and then below it is the proposed following consolidation. So you can see that during the working day, we're going from 7 vehicles down to 2, with the refuse vehicles pushed 1 in the morning, 1 in the evening, and then some overnight deliveries, which will be the consolidated delivery vehicles coming in, sort of outside of the peak hours. So as I've set out in paragraph 2.4.8, we are in fact slightly reducing the number of vehicles using the loading bay, and we are consolidating those and spreading them out across the time. So obviously when the original transport assessment was written, this was pre-consolidation, when there would have been a lot of vehicles using the service area, or sorry, the loading bay on street. With regards to other points that were made, I suppose, how do we, the monitoring? First of all, I understand within the Section 106, there's monitoring is a legal obligation with £100,000 penalty if we fail. So that's the sort of bond that we're being tied to ensure that we meet this. But secondly, the way the scheme works, and in fact this is for both schemes, is that there is a central parcel delivery area, if you want to call it that. In the 2018 scheme it will be in the basement, in the 2021 scheme it will be at ground level, but both within the service area. So we actually have a good ability to control the timings of stuff that's delivered, because we can have a booking system and we can refuse to accept deliveries at times when they shouldn't be doing. So if somebody turns up at midday and wants to deliver, and we've already, that this information will be passed on that they're not allowed, then they won't be able to do the delivery. So it's quite self-learning. Nobody wants to drive and then sit around for a couple of hours. So they will manage those deliveries, and by controlling where we accept the deliveries and what timings we accept them, we have a level of confidence that we can manage that system and ensure that the deliveries take place at the times we want. And because the consolidation is essentially a off-site, it is the one we originally looked at because it tied in with the hospital was a site in Dartford, but GPE might choose their own consolidation centre for all of their offices. I don't know how they're going to progress, but this is an out of London system where those deliveries that are normally just packaged, instead of going there, they are automatically directed to the consolidation centre. So it's not a case of arbitrarily a load of toilet rolls suddenly turning up at an inopportune moment during the day. Those should be shipped straight to the consolidation centre, where they're taken out of that vehicle, they're all stored together, they're put into one vehicle, which would probably be an electric vehicle, and brought in. And the types of vehicles we would use during the day, if there's slightly more urgent deliveries from the consolidation centre, will probably be electric vans, which will then go down into the basement. And overnight, those will be a lorry that could then turn up with the bulk of those sort of larger items and bring those in during the off-peak periods. And I know that Borough Market is a 24-hour destination, but that's less so for St Thomas Street. And the level of interaction we're talking about that's taking place in the early hours is as low as we can get it. And I think as a developer, we've worked through this to try and minimise those impacts. One of the other things that table shows you is that currently there is well, in fact, it was occurring that two vehicles would turn up within the same hour. So, this is only our development. I accept that there can be other developments being serviced with vehicles that could be there that we have no control over. That is always the situation for on-street loading. We're not denying that, but we can at least ensure that we are only providing one vehicle during any hour. So we know that we are not going to be conflicting with any of our own vehicles, so we can manage that. I suspect the loading bay might well have a time restriction on it anyway, in terms of, at the moment, for instance, it's limited to 20 minutes, but the TfL would probably put some restriction on timing in any case. So I think that, again, we can control that. And yes, there is always the possibility that there will be conflict with other delivery vehicles, but we feel that the proposal actually reduces the risk of that conflict and manages it better than the existing situation, which would be based on the existing loading bay. So I think that's most of my key point. I don't know if there's anything else you want to specifically.
No, I think we'll come back on the monitoring and that stuff. Anything more on the loading bay specifically, and then we'll move on to the smaller deliveries.
Can I just make a few quick points?
Yeah.
If that's okay. You're quite right that yes, we would have to consult on a scheme, and we are due to consult on that in the near future. But I think it's important to remember the difference between informal and statutory consultation. So informal consultation will be where we do more intensive work with local businesses, etc., and other stakeholders. Then we have the statutory traffic order consultation. And simply because someone opposes what we're trying to do is not in itself a reason for not progressing with the scheme. It just means that we are legally obliged to consider what their concerns are and take those on board, and if possible, adapt the scheme accordingly. You talked about the highway space outside the development, and you're quite right, but I think what I said earlier was that where you provide the loading bay, you would lose that additional footway space. So yes, in that section, you would be able to accommodate it physically, but in the rest of the section away from the loading bay, we would have much wider footway space to deal with the additional pedestrian footfall in the area. And in terms of the Oxford Street bays, again, you're quite right, but I wouldn't disagree that we have servicing on the highway, but the Oxford Street bays are primarily there to address existing businesses and not part of a future planning development. So the point I think I'm trying to get at in a roundabout way is that we acknowledge that servicing takes place because it has to, because of existing premises. But if there's a new premise, why would we want to create additional interaction on the highway?
And I've just one point about the timings of deliveries. And it's something that where TFO and the boroughs agree to disagree on this one, because I think in terms of pure network management terms, the deeper the off-peak, the better. If deliveries can happen overnight, great, because then a lot of our issues go away, because the service bay will be available, there will be less people around the footway, etc., etc. But of course, we often get the boroughs impose the time restrictions, and they don't like overnight servicing because of residents' impact on residents. And I'm not sure how many. I'm just speaking purely from a TfL point of view here, obviously, because it's not just us here. It's we're just a power authority. We're not the planning authority, but we try and push for deeper off-peak servicing to address some of the things we're talking about today, often with very limited success.
Is that an issue for this site?
Are there many residents around here? I guess that's really an issue for Mr. Glasgow, if he would want to answer that question.
Well, I'll put them to him now, Mr. Glasgow.
Well, yes, there are residents around the area. I think a lot of the upper stories of the properties on Borough High Street have residential accommodation. And I suppose there's the Shard Place opposite the site, which is a relatively new build development with residential accommodation. So they're the two categories of residents I can think of.
So would you, for the borough, be concerned about, I think you call it deeper, what's the term? I can't read my writing.
Deep off peak.
Yeah, deeper off peak.
Overnight, basically.
Yeah.
Overnight.
So yeah, really late at night, not sort of early evening.
I mean, I'm sure if I reviewed the comments from colleagues in the transport and highway teams at Southwark, they would have had views on the nature of servicing, whether or not they expressed particularly about deep off peak and the precise nature of when that would be. I'm not sure, but I can look into that.
Okay.
All I can say, obviously, we have presented our consolidation report to TfL and Southwark, and at no point have Southwark raised there being an issue with there being overnight deliveries. I mean, they're limited, and again, to be fair, we would expect most of those to be consolidation vehicles, which we would expect to be electric and thus quieter. Now, I'm not disputing that goods would still have to be trolleyed, for instance, from the loading bay into the property, but the vehicles themselves, it won't be like a refrigerated lorry turning up and running its engine and keeping itself going at 3 a.m. or anything like that. So yeah, we've had, as I say, the proposals were not raised as an issue timing wise with Southwark.
Okay. I was going to move on then to it's the yards and the service accessing from them, and then we'll come on to monitoring. So do you want to talk me through the concern from TfL's point of view in this element?
I think it's easy to lose track of focus on St Thomas Street. We do lose focus on the yards issue, and I know it's something when it first came in. I know talking to Southwark transport people as well, that was a big concern because the White Hart Yard is used servicing to a degree at the moment, and there are vehicles going down there. but having more vehicles go down, it doesn't quite seem, for a new development, doesn't seem right, because it's not, I mean, if you just have to go there and walk down there to look at and you think this is not a service access, this is not a street where we should be encouraging vehicles. It's a through, I mean, I'm speaking more from a policy perspective rather than a highway authority perspective, because it's a borough highway. But students for the business hospital use that link to go from Borough High Street to the hospital. So it is a fairly busy through. It's certainly not as busy as Borough High Street, but people do it. There's the sight line where the road narrows to one vehicle width for about 10 or 20 metres between Borough High Street, from the Borough High Street portal. It's literally a portal, tunnel portal. So just the practicality of, I mean, that can be managed, I know, but you've got vehicles, transit-type vehicles going up and down there. Coming out of White Hart Yard is very limited sightline. When I walked my bike out there and I had to dodge pedestrians, and that was walking a bike, and I couldn't imagine driving out of there, because there's the sightline is not there until the nose of the vehicle is out onto the footway. And given when I was there at 11 o'clock in a weekday, and I had to wait to get a gap on wheeling a bike. So imagine in peak hours, you imagine in lunch times, you can imagine on, it just doesn't seem right to be able to encourage more vehicles to do that movement. It should be, we should be basically closing off the yards, but I know we can't because there are existing users. And I don't see how you can make it any better, that sight line. You've got I think it's Wasabi there's a brick wall as you come out on the left-hand side. You've got Wasabi store on the right-hand side that you can actually get a sight line through a bit better on the right side. That's only because they've got a glass wall there. And nothing to stop them blanking that wall so that the visibility would drop even more. And you just have to go and look at it and to see that it's not standard, it's substandard, and going in as well. Pedestrians walking across, you obviously have to give way to pedestrians, so that means potentially blocking traffic to for a very limited degree. It's more about safety though, with not so much the traffic impact. And as I mentioned earlier, the number of cyclists down Borough High Street is greatly increasing, and just as a driver, you're looking to make a very tight manoeuvre into a very small space. You're looking at pedestrians, there could be cyclists come up inside you. That's bit of Borough High Street is probably the narrowest bit of High Street of Borough High Street in my experience cycling up there, and it just you just have to look at it and observe, and it just doesn't feel a safe place to encourage more vehicle movements. And that's irrespective of how the borough wants the yards to operate as a more pedestrian friendly place. And just I guess just on the point of just preempting monitoring, whenever the monitoring regime, it's TfL as the higher authority has to pick up the pieces if things go wrong. I think that's I was just thinking about St Thomas Street as well. That if people are parking footways, if people are, God forbid, knocking people down, we have to explain things. I remember one of my colleagues saying that if someone gets killed on the TLRN, he has to go and give evidence, and it's a coroner's court. Why did this? And their questions of why is this happening? Why do you allow this? Who made this decision? So things like that, and practical stuff that. And again, it's a risk factor. An accident risk is really hard to quantify. And the applicant will say, well, we're doing our best to consolidate. The numbers of movements won't be that much more than it is now, but every additional vehicle going in and out of there is obviously an extra risk. And we've got the mayor has charged us with delivering Vision Zero, which is a mayor's transport strategy policy. But you probably, there's a Vision Zero strategy, and that's saying no killed or seriously injured on London's roads by 2041. And clearly, if you allowed the 2018 scheme, there would be an increased risk of accidents, of collisions on the road, on the TLR. But quantifying that risk is difficult, isn't it? Is it one vehicle extra than a White Hart Yard or 100 vehicles extra? It's, every vehicle increases accident risk, collision risk.
Can I just add a little bit more?
Someone needs to turn the microphone. Oh, there we go. Yeah, flash.
Yeah, just in terms of egress from White Hart Yard, in addition to the intervisibility issues between vehicles exiting and pedestrians walking along the footway, one of the problems is that, particularly during busy periods, the vehicle will have to edge out. Now, if there is traffic flowing southbound along Borough High Street, it means that they will then stop and give way to that traffic, but by doing so, they're blocking the footway, and there's no scope for pedestrians to walk around those vehicles because White Hart Yard is so narrow. And so one of the problems that you have is people then start walking around the vehicle into the carriageway as well. So that's an additional safety issue. So what happens a lot of the time is that those vehicles exiting will rely on the nearby pedestrian crossing, giving a vehicle a red light so that they will be able to gap access and then drive southbound into Borough High Street.
Thank you. Mr. Glasgow.
I suppose Mr. Hurley and Mr. Birch have talked about the fundamental challenge with vehicles entering and exiting White Hart Yard. I think from the council's perspective, it's worth considering also the character within the yard. As Mr. Hurley and Mr. Birch just mentioned, it's very constrained. There are very few opportunities for two-way traffic. There are other sort of tensions. So there's lots of Sheffield stands for cycle storage opposite student accommodation, which has one of its main entrances into the yard. So the intensification for vehicular use has been raised by the transport team at Southwark consistently since the pre-app and through the determination process has been something which they fundamentally were not comfortable with. In the context of Vision Zero, as Mr. Harley just mentioned, just given that any intensification of vehicular use in the yards just increases the potential for conflict. And one of the points I alluded to before when we were discussing the monitoring that will accompany the 106 agreement, I have to admit I'm not entirely sure if this detail's been agreed yet, but there would be some sort of bond, and if servicing trips exceeded the estimated numbers, then the council would have the ability to recall that to invest in further mitigation. I think the challenge with White Hart Yard, as we've just heard, is that the fundamental concern really is on the entry and exit, and it's difficult to think of how that can be mitigated, just given that it's an existing physical constraint.
Thank you. Okay. Mr. Vaughan.
Fine. Yes, again, a number of points raised there. I mean, one of the starting points I suppose I would make is TfL, they've highlighted all these issues, and yet, again, within their Stage 1 report, they accepted that it was mitigated to a suitable degree and was acceptable in principle. So it's a slight sort of change of view. Now, in relation to the constrained nature of the yards, in particular exiting, I'm not disputing it is a narrow entrance and it has very limited visibility, and certainly if it was a new development you would not design it as it was. However, that is part of the grain of the highway network through London, and it is tight. Now, that said, it's key that people drive according to their conditions. If you think about when you drive into a parking bay at Tesco's and you have cars on either side, and then you reverse slowly out with poor visibility between two cars, and you don't knock people down because you're driving very slow because you're aware of the precariousness of that situation. In the same way, anybody who's exiting the yard has already driven in, so they know that route, they know what they're crossing, they've seen the footway, they understand the situation, they're not suddenly just popping out there with no experience of what they're coming on to, and they drive accordingly. And in that situation, as Mr. Hiley highlighted with his bike, he has to edge out very slowly, waiting for a gap. And that's probably the reason why, when you look at the accident data, there have been no accidents in the yards or at that junction. Which is a different scenario to say on the main road, next junction up, where all of the accidents, the actual sort of serious injuries, are all being taking place on Borough High Street, and I think it's Southwark High Road to the north. So when they're talking about Vision Zero, here they're looking at trying to mitigate a site where historically there has been no accidents, as opposed to various other sections of the network on Borough High Street where there have been, in the last 7 years, recorded accidents and injuries that I assume the Mayor is keen to try and mitigate against. I think when they are pulling out, we have that. The situation is also being improved by TfL's scheme of widening the footway along there, because that will encourage pedestrians to walk slightly further away from the buildings. So in other words, the key issue is somebody who literally just pops out from behind the building. So the further away they are, the greater your chance of seeing them is before you get to them with the vehicle. And it also assists with vehicles pulling in, because previously the left turn in had a situation where, as you left turn in, you're sort of cutting across, and potentially there's a greater risk of a cyclist coming up your inside and you cutting across, and technical term is side swiping them, in other words, hitting them with the side of your vehicle as you pull in. Now, because of the proposed widening that's in there, and you can see it with the coning off that's taken place, that actually gives them a protected area to swing in, so it allows them to get the vehicle straighter as it's going through the arch, which makes that whole manoeuvre easier and better for the drivers. Ultimately, as we've highlighted, originally in the scheme, when Southwark and TfL both had their valid issues with it, we were looking at there being 76 vehicles, 76 vans coming down here during a day. We've now reduced that down to 23 across a 24-hour period. It's worth noting that, excluding the 8 hours where we won't be doing any deliveries, that's, again, there will be no delivery during the AM, the PM, or the lunchtime peak. But if you were to spread those out across the 16 remaining hours, that's 1.5 hours. Now, being practical, we know that won't occur, but within my report, I've highlighted, we're assuming 4 vehicles an hour. So when we're looking at unacceptable safety issues, what we've got to ask ourselves is an extra vehicle coming out of this access every 15 minutes in a few hours, spread across, I think it would be 6 hours, that would be, but as a maximum, 1 per 15 minutes, is that an unacceptable increase in risk? And again, those drivers, a lot of those people coming in will also be the regular drivers. They know the situation, they know the route, they know the issues coming in. They will be the consolidated van drivers who, again, will have an understanding of that situation. So it's an occurrence that they will get used to and understand and work out how best to minimise any potential risk. And ultimately, the question will come down to, is those additional 4 vehicles an hour at a maximum pulling out across that access unacceptable from a safety perspective? And as I say, we were under the impression, given that TfL found it acceptable in principle, that they agreed with us that it wasn't.
Okay, just on the point of behaviour, obviously, you've talked about the behaviour of the delivery drivers. They'll know it's narrow, so coming out. What about the pedestrians then? So we heard about the risk, and pedestrians, if the van's inching out onto the pavement and they can't get out, and pedestrians are then having to step out into the road. I mean, they're people that might not be familiar.
Yes, the onus is entirely on the driver, as it is in all these situations. As a driver, you have to assume, for instance, that somebody is going to keep pushing their buggy out in front of you or whatever. Again, one of the points that was an issue was that the narrow footway meant when the vehicle had pulled all the way across the footway, you cannot get behind because the access is so narrow, you can't actually walk behind the vehicles. With the proposed curb widening, there is an improvement that certainly on the shorter vehicles, the smaller vans, when they pull forward to, let's call it the giveaway line, the edge of the carriageway, people will be able to access behind. Now, the other thing to put this in perspective is, if you think about this, this occurs every time a side road crosses a busy footway. There are drivers stopping at giveaway lines and pedestrians walking perpendicular to them along the footway. It is a common occurrence. Pedestrians are not surprised to have vehicles pulling across and stopping in order to get out onto the highway. Admittedly, there might be work that could be done to further enhance the obviousness of those crossovers. So, for instance, the footway could be treated differently to ensure that it's a bit more obvious. And these are the points that can be picked up in detailed design going forward if there was, in relation to Section 278 works. But in essence, it is in my opinion, a safe scheme. It is not, as I say, there are not a history of accidents there, and it is continuing to operate with only a marginal increase in the number of vehicles. So yeah, from that sort of point of view, and as we know, the other point is that through this scheme, because we're using White Hart Yard for all of it, we are also therefore potentially reducing the vehicle flows on Kingshead Yard, because at the moment we have a car park there, although people don't drive into London anymore, but there are still deliveries that can use that, and we are ensuring that that isn't used. So one of the flip sides is that we could, for instance, have decided a one-way system where they came in through one yard and out through the other. But it was agreed with Southwark that this was a better solution to try and segregate, so that there is still, Andrew was talking about the pedestrian routes through, and there is no dispute that pedestrians will still choose to use White Hart Yard. But in addition, they could, Kingshead Yard is not much further up the road and will be very lightly trafficked. We will have no traffic on it. We're improving all of that. We're making it a better pedestrian route, and it leads to the same destination. It still leads to the same arch through into the hospital. So it's not any level of detour. It's two sides of a square or two sides of a square. And when you're looking at the other benefits, yes, we are increasing the conflict, although minimally, between vehicles and pedestrians in the yards, but we're also removing pedestrian congestion on the corners of, for instance, St Thomas Street and Borough High Street, because we are providing a new access into the station, which will allow all the people travelling to the east to come through our public realm and directly into the station, instead of having to go up the footways, round the corner and back on themselves. So there's, it's a complicated mix of benefits and disbenefits for the scheme.
Thank you. Do you agree that it's a mix of benefits and disbenefits, having just heard what we have?
May I just raise some points again very quickly, if that's not possible? Just to be clear, though, that the footway widening, that's not a permanent scheme, so it's there for the duration of the pandemic, whereas the development is a permanent building. You talked about there being no collisions, which is a perfectly fair point, but one of the things that we've now said in our Vision Zero action plan is it's not just about looking at remedial work for collisions, it's about preventative measures as well. So we don't want to be doing something which creates more conflict. In terms of Kingshead Yard, I don't really see what the advantage is, whether it goes down King's Head Yard or White Hart Yard in terms of interaction with pedestrians. So you could split it 50-50 or 60-40 or what have you, but there's going to be the same number of interactions between vehicles and pedestrians. You also talked about at standard priority junctions where vehicles don't necessarily give way to pedestrians. There is different visibility at those junctions. I think in this scenario, pedestrians don't have that much choice, or drivers don't have that much choice because there isn't that intervisibility. But it's also worth noting that the Highway Code was recently changed to specify that vehicles should be giving way to pedestrians. But I don't see how a driver of a vehicle would be able to do that if they can't see the pedestrians.
And just a couple of points, picking up on what John was saying about the fact that there are no accidents outside White Hart Yard is a good thing. We want to keep that way, obviously, because it shows that it's just about working at the moment. We can't say for certain whether it will get, inevitably the risk will increase with more vehicles going through there. And I know there's a lot being said about it happens elsewhere in London. But I think in one of my rules of planning, I know it's not a rule of planning, but two wrongs make a right, that the fact that it's working somewhere else substandard doesn't mean that we should accept in a new development the same situation. When there's what we're often thrown at me, it always happens over there. But every situation is different. And just on the point about the accepting it before, I mentioned earlier that we had planning reasons the GLA found were more compelling than overall the TfL position. And other things that are subtle policy changes, such as Vision Zero healthy streets, are now much more ingrained. I think in 2018, the London plans a draft. So a minor point, but I would imagine my predecessor would have been saying exactly the same things back in 2017, 2018. And it was without the knowledge of, I know you said you can't consider the 2021 scheme separately, but we now know there does apparently is a potential solution off street. So I would argue that the goalposts have changed subtly since my predecessor worked on this scheme.
Thank you. Mr. Glasgow, just in terms of policy, do you think it's been strengthened since 2018, as has just been said?
Well, I think it's quite clear in London plan policy on servicing, firstly, that there's a simple premise that all servicing activity for major developments is undertaken within the confines of the site, where possible. We've discussed that point earlier on this afternoon. And I think one of the significant differences in the new London plan, which Mr. Hiley has referenced, is the introduction of the healthy streets principles. And that's both in a transport perspective in policy T2, which sets out all new developments should sort of make sure that the indicators are all followed and that vehicle dominance in London streets is reduced. I think we just discussed in the last sort of 10 or 15 minutes, one of the concerns of the council as a highway authority is that even with the consolidation this scheme would introduce, it's unquestionable that the intensification of White Hart Yard for servicing vehicles would increase the risk of conflict between the different users. And I think from the council's perspective, it's worth just mentioning that the yards are a distinct historic characteristic of this part of the borough. I think there's just a fundamental concern that they are not suited to the demands of modern servicing. And in my brief, I've drawn attention to the fact that partly in response to that, the council had been working with the two business improvement districts in the area, Better Bankside, Team London Bridge, to look at interventions in White Hart Yard to enhance the pedestrian experience rather than the vehicular experience. But just one more point in the context of healthy streets. I think whilst it's mentioned in the London plan as a transport theme, it's also fundamental to the pattern of growth that the London plan tries to promote. In the initial chapter of London plan policy GG3, good growth, talks about creating a healthy city and does make clear that more generally patterns of development should be using the healthy streets approach to prioritise health in all planning decisions. So I think that's a more rounded way in which the development plan now approaches this issue.
Thank you.
Just for clarification of dates, the GLA report where they stated it was acceptable was the 26th of July 2019. So it was quite, so we'd already submitted and then we did the consolidation. On the back of the consolidation was when it was viewed. So it wasn't when the 2018 scheme was submitted. This was, I think, whereas Vision Zero was July 2018. So, you know, it had been around for a year by that stage when they said it was acceptable. And I think the other point, just from Mr. Birch's comments about visibility, just to confirm, I'm accepting there is a visibility issue when exiting and the drivers have to drive appropriately and manage their speed appropriately for those. But what I was suggesting, I suppose, is once the vehicle is pulled out across the footway to then move onto the highway, at that point there is not a visibility issue. In other words, the pedestrians know the vehicle is in front of them. You know, it's only when it's edging out of the access that there is a visibility issue. And equally, when pulling into the access, there is good visibility, albeit that doesn't negate the fact you've got to find a suitable gap in the pedestrians to manoeuvre into the yard.
Okay. So what did you want to say something, Mr. Glasgow?
Just one very brief point, if I may, because it's been raised a couple of times now, and it's just in relation to the GLA's stage 1 response and I suppose TfL's ongoing inputs into the submission of the applications. And I think that the parallel to draw between the GLA's stage 1 response is probably with the council's statement of case, insofar as it's addressing a whole range of planning matters and trying to come up with a rounded conclusion. I think from all the material that I've been reading over the last few months, both the council's transport and highways teams and Transport for London have been consistent in the messages that the servicing solution creates problems. I don't think the GLA's stage 1 response changes that.
Okay. Are there any more points to make before we move on to monitoring specifically on any of the aspects of the servicing that we haven't covered? No, now's your time to shout off if. Okay. In terms of monitoring, then, do you want to?
I wasn't anticipating a big conversation on the section.
Neither was I. So don't we can pick it up also in the section 106 section as well. But
I think we should. We've got the council solicitor and TfL solicitor who have been advising on section 106 in the room as well. So do speak up if I say anything on behalf of all of us that isn't correct. So I think the only points really to make is that in accordance, so we're kind of luckily in a position where Southwark are, we're working on a negotiated section 106 agreement. And we're very much using Southwark's standard form drafting, and then TfL more recently have been engaged, even though they're not a landowner within the application boundary, but because there are obviously benefits, particularly in terms of the station entrance. So TfL have just in the last few weeks been engaged on the section 106. The delivery and service management section of the 106 is, as far as I'm aware, settled and agreed. It's very much based on the Southwark standard, which includes putting daily caps on vehicle movements, and that's specific to both St Thomas Street and White Hart Yard. It also includes prohibitions on certain hours, which aligns with that diagram, the image that Russell referred to. And in terms of the deeper, I've forgotten the term now, peak. The deeper off-peak.
The one I keep forgetting too.
There are no restrictions overnight. So on a weekday, it's exactly as per that image, where after 7 o'clock in the evening until 7 a.m. in the morning on a weekday, there are no restrictions. and on weekends, the same is true between 11 o'clock at night and 1 o'clock in the afternoon. So all of that is set out in the management plan. Separately, there's a delivery and service monitoring plan, which again it's not specific to Southwark and the London boroughs, but it's a constant on Southwark. Sophie, correct me if this is wrong, but I think it's certainly on all the schemes that I work on in Southwark, which tend to be tall buildings. So the more major schemes, there is a monitoring plan which goes alongside the management plan. The monitoring plan has to be approved prior to occupation, and includes obviously the methodology for monitoring, logbooks, a contact for the person that will monitor, and then there is this £100,000 bond penalty, call it what you want. I don't know how that's calculated. I think that is different between different projects, I suspect. But that's what we've got here. It's all been agreed, and it's agreed with TfL as well. So I think in terms of a suggestion that it's going to be difficult to monitor, it's the same as the Edge scheme along the road, the Vinegar Yard scheme along the road. This is how consolidated servicing management is controlled in Southwark, and it's very similar to over the river in the city, which on all their major schemes has consolidation as well. And I think that probably picks up the point, and then we can come back to it.
Okay.
The bond is the £100,000.
Okay.
And that the way that operates, the monitoring plan is a 2-year plan that kicks in from 75% occupation. It has to be agreed, I think, before then. And then at the end of that 2-year period, there is an obligation on the developer to submit essentially an audit as to what's happened, what's been going on, and it's then there's an ability for the council to retain all of that bond. So there's no kind of pro-ratering. You've either met it or you haven't, but the obligation to continue to comply with your management plan, that's for the lifetime of the building from first occupation. And of course, that would be a breach of your legal agreement if that wasn't done. So irrespective of this bond, which is more of a Southwark issue, there remains an ongoing management, which includes your caps and your prohibition on hours.
Thank you. Any comments? Can you come and speak into a microphone just for the live stream? And what was your name, sir?
Steen Smedegaard. I'm a solicitor with TfL and GLA, and also sorry, Steen Smedegaard, and I'm a solicitor with TfL and the GLA also. Just in terms of Section 106 agreement, again, I wasn't anticipating going into the details of it today, I'll be honest. So I cannot confirm at this stage whether TfL has agreed to all the provisions. I know we looked at them in detail, so I just want to put in that caveat, but we are looking at the agreement again this week, so we'll come back with further comments.
No, just there are points outstanding between us and TfL on the station entrance and the development agreement and LUR's easement. So there's no debate. We are still continuing to negotiate that, but on the delivery servicing provisions, my understanding is it's settled. But
I can't confirm that either way.
Yeah, I appreciate I've put everyone on the spot here this afternoon, including myself. So yeah, okay. Okay, thank you. Okay, I mean, yeah, we will pick up on the Section 106 and then in specific things in the specific session towards the end of the inquiry, so we can have an update on that and if there are any loose ends in that regard. Any other comments in terms of servicing? It's been helpful to me this afternoon, so thank you. The roundtable ones, they're good just to give me an idea and get my head around it a bit more in an easier sort of way. Any further comments? If council first?
No, I don't think so.
No. Okay, thank you. TfL?
No.
No. Okay. And
No comments from me.
okay, well, thank you very much, everyone. We've 10 to 4, or a little bit earlier than predicted as well, even better. Okay, well, thank you everyone for your efforts. I do actually, we've got this list of building site visits, but I need to obviously go and have a deeper look at the servicing issues. I think a lot of it, I don't need to be accompanied unless there's a particular desire for me to have an accompanied visit with yourselves. But instead of that, if I did it unaccompanied, but if I was to set you some homework to do me a little itinerary site visit to follow specific areas you want me to have a look at.
Although tomorrow, certainly, I mean,
yeah, it doesn't need to be tomorrow.
Yes, Dr. Barker Mills is coming. He's not really an expert.
No, he's not. He's not an expert. Well, I don't know
speak on his behalf.
Anyone else can come along from the council. Certainly, when I did my little tour, it's just inevitable that you see the service report.
Yeah, I mean, I can have a look tomorrow, but if there's an itinerary, I can just go one night for an hour after we're sitting, just to. Absolutely. So I'm specifically looking at that, just so it doesn't confuse my brain. That tomorrow I'm looking at listed service bays if I get confused, that kind of thing. So yeah, okay.
Well, you'll be in one of them tomorrow anyway.
Yeah.
On site, you'll have to be in the car parking.
Yes.
I've certainly seen cars. And I don't know who these people are. I don't drive into London, but the car park and the lorry and the servicing yard on the site you'll have to see tomorrow, because it's part of the on-site tour that you can't see.
Yeah, absolutely. Yeah.
On the site.
So if there's any specific areas that are unaccompanied, so me just seeing them on my own, that you want me to see, if you can just pull something, doesn't need to be anything elegant together, but just to please go here, 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 and here, and I'll do that at some point, just to tick everything off. Okay. All right. Well, thank you, everyone. It's been a good first day, 4:00 finish. So tomorrow we'll come here for 9:30, and we've got the presentation that's about an hour and a half, I think, and then we'll go off and do the site visit. I'll probably go and get changed before I come around and do the site visit. Just to be comfortable as well. Yeah, my boxes have arrived now. So and yeah, everyone that's accompanying us on the site visit, just be comfortable as well. It is going to be cooler, but we'll not take it for granted. Is it rain? Is it forecast rain? Oh heck. I haven't brought a raincoat, so if someone's got a brolly, that might be quite handy. Okay. All right. So we'll finish today and we'll reconvene here at 9:30 tomorrow. Okay. Thank you.